What's up, everybody? Welcome to another Operation Wisedome. It's Saturday morning, February the 9th of 2025. Um, sorry I missed on Wednesday, everybody. It was my birthday. I done turned 38 years old, so I'm getting up there, man. I'm getting to my 40s, which is I'm pretty happy to at least reach this age because I wasn't supposed to, or I was supposed to, but there was a glitch in the matrix, and some things happened, and they brought me back. So I'm just really excited, and we've had a lot of cool things happen this week. We've had a lot of successes, dismissals, two of them for sure. We had, one last week with David Slaw, and then we had two this week. Another David, I believe, and then we also had, who else got dismissed this week? Who else was that? Dan Edwards got dismissed this week. So that was crazy because he was so worried about his warrants and just a whole bunch of stuff. Here goes my boy Bob. Come on in here, Bob. What's up, Bob? What's up, Bob? What's up, Bob? And we've had some really good dismissals this week, so that's been pretty crazy. Catching up with everybody has been wild, but I'm finally doing such. At least in the Discord, I see that y'all have been getting back in the Discord and getting active again, so now I can start working more. But just know, if you see that the Discord is getting caught up with everybody in casework, that doesn't mean we're all the way caught up. There's a lot of people, or quite a few, at least 5 in emails that I conversate with, just because they're not so good with Discord. And then at least 5 to 6 in my text messages that just don't get in the Discord either. So we're steady working. We've got over 40 different people that we're working with directly, as far as helping to empower them directly on casework now. And something else that was pretty crazy is yesterday I got a call. I just want to tell this quick story before we do intros. If there's anybody in here new for the first time, I don't think there is. I don't see anybody new right now. But I just had a call yesterday with this guy named, I think he's in here. I think his name is Steve. And we finally got someone that got an injunction filed on their ass. So now we finally get to go against them filing injunctions against us, right? Because you already know that we are going to be filing injunctions if things don't go right in our scenario. So it's good to finally see that we have injunctions being filed against somebody that we can help. Because again, like I said, we know that those injunctions are the deepest aspect. Of course, with, your writ of mandamus and all those things. But yeah, we got someone that we're going to be helping over the weekend. Steve, I think he's in here. And he had an injunction placed against him. And he's a full testament of how powerful they are. And so I just want y'all to know that, these injunctions don't play around. And when I'm telling you they're the deepest of like the deepest, they don't play. It's real deal. It stops everything. Everything. And I'm sure Steve could come on and tell if he wanted to. But actually, Steve, since you're in here, why don't you come on up and do if this is the Steve, I don't know, it might be a different Steve. It might not even be Steve Ellie, but is there anybody in here new for the first time? Yes? No? No? Y'all all got y'all's video off today. Y'all must be sleepy. It's all good. Y'all gonna leave me and Rich up here all by ourselves to sit here and be on video. That's cool. Okay, Erica, put the police report. So, if we've got nobody on new this morning, and there's only 15 of us here, which is a little bit wild, but okay, then I want to see what's going on. Doug's working. Okay, good, Doug. Steady working. You can listen in then. My eyeliner is off today. It's all right, Ramon. No worries. If you're not looking as pretty as you want to, there's no worries there whatsoever. So then what we can do is, I got a couple different things. So let me see here. Let's do this. If y'all ain't gonna come up and tell me how y'all's week's been or anything, y'all just gonna have me straight going in on what? Y'all better come up and say hello to me.
Hello.
Hey, Cameron.
What's
What up?
Happy birthday!
Okay, happy birthday, bud.
Yeah, y'all better get active today. There's only 15 of y'all, so I'm gonna be feeling bored if y'all don't come up and start talking to me.
Okay, I got
Thanks,
something I can bring
Cameron.
Okay. Yeah, what's going on?
So I've been doing some studying about all the different bonds, and so I guess it's not only the bonds that go into a sludge fund for the judge, but it's also possibly all the court fines, all the I mean, pretty much everything that goes towards the court goes into a sludge fund for the judge. So there's a bid bond, appearance bond, performance bond, the GSAs into a sludge fund for the judge. I kind of want to be calling him out on that shit.
Okay. Now let me ask you this: if you call him out on it, what success do you think it's gonna have?
I don't know. It would be privately, like I'd send him an email or something, be like, so what's up with this this crisp sludge fund and these bonds that all have my principal's name on it that you're benefiting from. What's going on with that?
Okay. But what do you think how do you think it's going to benefit you?
Oh, it probably, well, I don't know. It might. I'm just hoping to see a look on his face or, yeah, go.
They're not going to admit to that type of stuff.
Oh, probably not. Probably not.
It's funny you mentioned that because this letter just got sent over to me.
There's a woman. Anyway,
Erica,
this woman,
you lagging.
she pulled the bonds. There's a process, and if you're going to do that, sorry.
It's okay.
Can you hear me now?
Yeah, we can hear you. You're just lagging. But we can hear you fine.
There's a woman here who did that, and there's a process that you're supposed to follow if you're going to do that, and she followed the process, and they called her in, and she ended up in jail, and she went to Texas, and then they held her, and they arrested her like as soon as she got off the plane in Texas, and she just got back, and she's been in Texas for like months in jail. I wouldn't recommend messing with there. If you don't follow the process correctly, they will retaliate in not a kind way. So just be careful.
I'm sure they would. Thank you. I appreciate that. Yeah, I'll look into it more for sure before I actually would ever do anything. But I just thought it was fascinating, disgusting.
But of course there's a fund for that.
So
If you're interested in the bonds on everything, you should go look at your straw man and stuff like that.
Okay, so check it. I got this letter from somebody, and I don't take this really with too much, just due to the fact that, like, what is this? It's a great letter, I guess, but this is apparently an example letter to the judge with the bonds aspect to notify them. But again, I don't know what this is or what it's supposed to cease and desist. They apparently fraudulent bid bond, performance bond, and payment bond associated. I'm sure there's some aspect of where there's some depths to it, but I've never seen anything be achieved with this. So I don't know, maybe there's some people that can speak on it that got a little bit better experience with it. If they've done it, I ain't done it, right? So all I know is how to articulate my knowledge, right? And I try to stay away from as much as possible that back end stuff that gets people caught up and in trouble, or just too much of the theories that will allow us to just have issues altogether. I try to stay away from that. Even though I do comprehend quite a bit of it. I think I was talking to Thomas earlier this week, and it's like I told Thomas, it's not that I don't know a lot of things that I could dive into, it's just that I can't verify them. So if I can't verify something and give you factual data that allows you to move swiftly to where you're not going to get in trouble, what do I look like telling you about it? Because at that point, I'm just giving you hearsay. I'm just giving you something that I cannot back up. And I don't ever want to do that to anybody. I always want to get factual data because, go ahead, Bob.
Is there the notice of liability that one can serve on the sheriff? Can one do that at the judge?
Yeah, you can do that with anybody.
Would that give some protection if the judge violates the rights of Erica?
Okay, so let's look at it like this. Let me find something.
Technically, they already have, because when I got arraigned the first time last year, the judge entered a plea of not guilty for me, which is I think why they're wanting to redo it. I've been looking for the audio clip of that hearing to send into the Discord, but I'm not. I gotta find it.
I don't know if it would be untimely to do it at this point.
Well, you can always
Could we
challenge
use-
jurisdiction at any point. So, let me
Could we
see. I think
use
it's
the-
this one.
the administrator's admission of not guilt for a motion dismissal on the grounds that the administrator found us not guilty? Just quick.
Ask that again. You were low.
My point was kind of apples and oranges. This was more or less to go after them in their pocketbook later.
Okay, there it is. Okay, so where is the Zoom now? I'm so lost. Too many tabs open. All right, so if I do share, we come over to this one, share. All right, so if we're just looking at a couple quotes when you're talking about the judges itself, right? Government officials, judges not immune from suit. Quote, immunity fosters neglect and breeds irresponsibility, while liability promotes care and caution, which caution and care is owed by the government to its people. Okay, Rabone versus Rowan. Then you got government immunity. In Land versus Dollar, the court noted that when the government entered into a commercial field of activity, it left immunity behind. Brady versus Roosevelt. The high courts, through their citations of authority, have frequently declared that where any state proceeds against a private individual in a judicial forum, it is well settled that the state, court, municipality, etc. waives any immunity that counters cross-claims and complaints by direct or collateral means regarding the matters involved. Then, another one, quote, when enforcing mere statutes, judges of all courts do not act judicially, and thus are not protected by qualified or limited immunity. Okay, judges not only can be sued over their official acts, but could be held liable for injunctive and declaratory relief and attorney's fees. The immunity of judges for acts within their judicial role is beyond cavil. There is no common law judicial immunity. Okay, so yeah, she can go after them damn judges without no problems whatsoever. The only thing is that is she gonna be able to articulate herself well enough to be able to sustain the aspects, the attacks that are going to come forth, because they're going to hit her in the court hard. They're going to try and railroad her hard. They're not going to be playing with none of that. You know, they're going to come in very hard. As soon as she wants to say something, they'll be the ones to be like, shut up, or they'll be like, we're not hearing this today, you know. And that's when we get into the aspects of constitutional violations, due process, and everything. So of course, I do think there's a lot of different aspects that are at play with Erica's situation. But one thing I just got, what's up, Troy? What I gotta have everybody remember is that they have to go through the process. And if you don't want to go through the process, just hit them with an injunction. Especially if you're not trying to build a case against what they got going on. And it's like Erica realized she's the only one that's going to work the hardest for her case. Now, she turned in paperwork yesterday to get rid of her current attorney. And I still think that it would be beneficial for her right now to get a court-appointed attorney. Me, personally, I do. I think it does. I don't think Erica's all the way ready. So I think she should get another court-appointed. And what we should do is have a plan of action to say, okay, get a new court-appointed attorney, get yourself educated so that when the first time you're going to meet this court-appointed attorney, you're going to come in there not on not knowing side, but knowing side, coming in with an outline of how this conversation should go between you and her, and then have all of your documents that we can develop together right now in the next 10 days to say, hey, look, I want to, I've developed this for you to file on my behalf. Instead of filing it for yourself, have them file it, have the conversation, have the theory, have the outlook, go over the video briefly, not the whole thing, because they ain't gonna have time to go over that whole thing. But if she was to briefly go over, say, listen, here's 5 minutes, here's the very intro of everything, boom, here's another 5 minutes or 2 minutes of them conversating together right here, boom, here's another 5 minutes of blah blah blah. That's all you need initially for the lawyer to get to working. in conjunction with the paperwork. And so that's what I think that's kind of been my advice. I wanted to see, like, what does everybody else think, knowing a little bit of Erica's situation, or should we just look a little bit more for y'all to get a better mind frame to kind of give, because that's what my advice has been. My advice is don't just jump into this and attack it. I don't think you're ready. And then, but I think it would be nice if she utilizes and takes the time to get another court-appointed attorney, submit the paperwork that we developed to that attorney, and say, hey, look, I've already made this for you to file. You ain't got to do a lot of work. I've been doing a lot of study. I'm in this pro se group. We're really working hard on my case to try and figure stuff out. This is kind of the outlook as far as the plan of action we want to go, and see where that leads, right? Because if we're getting issues and you're recording these interactions that you're having with the public defender, then you can kind of just see, like, I don't know, you're learning. It's all learning experience first off. And I don't know, what do y'all think? Y'all tell me.
I think it'd be good for a lot of people. We need to figure out how to work with these public defenders and stuff. I think is good, because a lot of us aren't good at presenting ourselves in front of the judges. And if we can figure out how to work with them, for those people especially, I think it would be beneficial for many of us.
Right. I believe you're right, Troy. I think we need to have some way to have Erica come in with a summarization of the details that she's going to hand to her public defender for him to go read and present, summarize himself with, to present. I mean, she doesn't present the whole argument. She just summarizes to him so he can go read for himself. So we need to present a summarization for Erica, I believe.
No, I think so. And that's what I say. And I think like a good summary of everything, maybe an aspect of being able to put a 15-minute video together to kind of condense it, pause where we need to if she needs to explain it so that it's not too much for the judge or for the attorney, and then come in with things that are already drafted as far as paperwork. So like a motion to dismiss, suppress, whatever the case may be, as far as a dismissal on the constitutional side, applied as unconstitutional, right? Because there's just so many aspects as far as what's going on with hers. I feel like it's dangerous for her to go in all by herself, And when you get in here and you don't know everything, like even I don't know everything. If I'm gonna say I know everything, y'all be crazy, man. There's so much to learn, so many different aspects, so many different approaches to take, so many different writs. Are y'all crazy? And everybody's situation is different to allow us to work different angles. But maybe even another probable cause hearing being called forth. There's just lots of different things, and I think if we present all drafts over to the attorney, then that gives the eligibility for the attorney to say, look, damn, they've done a lot of work here for me. All I really need to change up is this, or this. And I've spent, 30 minutes to an hour of my work rather than, 5 hours drafting up something. And I think that'd be the best, because if you have any issues with them again, then it's like, okay, well, you've utilized that time to learn. You've utilized that time to at least move the court, hopefully in some type of aspect. And if the public defender is, again, not working in your aspect, then it might be time that we start, asking for another one, or just try and hit for an injunction. It's kind of hard. I definitely want to, we're definitely going to have to talk Erica. And then, because, I have people like Hayden who has completely gotten away from everybody, right? He's like, he had an attorney, he paid $5,000 for his attorney saying they worked 56 hours, they only filed one motion. Then we get to talking, for 2-3 days later, he's got, 7 different documents. He's like, holy shit. And then I start leading him in the right direction. He's like, dude, screw this attorney. I'm doing this myself. So I get it on people with those certain aspects, but you also got to remember too, you got 3 cops now. It looks like 3 cops who are conspiring against you. Don't know why. I don't know why people gotta be evil like that, but I don't see nothing being hit, and it's hard to prove without a reasonable doubt. But I ain't gonna lie, I talked to my pops about it, and he didn't watch it. We just talked briefly, and my pops was like, "Man, jury's gonna be not good. It's not gonna be good on your favor in that one, because the jury is already." The jury, it's like we understand the jury is not, they don't understand the law like we understand law. So what it's going to be is you're going to have to really, you or the attorneys really going to have to pull the jury to comprehend that this is without a reasonable doubt, and we need to see the damages. Where are the damages? Did you say they had pictures of him by chance too, of like his face? Oh, you're muted.
They just took a screenshot with their body cam of his face, but because the flash went off, it's so bright you can't see anything.
No, they didn't. Well, they had to have taken pictures at the hospital or
did not get any of those if they did.
Okay, good. That's good. I mean, if you haven't gotten none and they've given you everything else, that means that there is none that they're going to utilize as far as evidence is concerned. So it's y'all tell me what y'all think. Do y'all want to watch some of it or what? What are you going to do? Tell me, because I've got a couple different ways I can go here, but
Tamara's going through the same thing, it looks like, too.
Say it again.
I said Tamara's going through the same thing too. She was assaulted pretty bad by a bunch of cops.
What's up, Wallace? How you doing, Papa Bear?
I'm all right, man.
All right, Papa Bear in the house. What's going on, my boy Wallace down in Florida? Where it's all hot.
It's one thing to fight a traffic stop and there be limited interaction like you've gotten, and then there's another thing where you got 3 cops that have already done you wrong. I definitely agree with the whole lawyer aspect and giving your information. They're advising you, or you're advising them, and you're asking them for their advice.
Well,
This lawyer that the attorney thing, they do mitigation. That's what they do. They work with the court to mitigate damage, or the outcome of it. You might not, like the lower charges and whatnot. That's what I see in it.
Yeah, I mean, by the PS, I live in the most corrupt county in the state. Like, it's known.
You're in Arizona, right?
Yeah.
Okay, well, we're gonna have to be working on yours in the back end, that's for sure.
May I?
There's a lot of drafting to do, but I think, like I said, they have to prove without reasonable doubt. So if there's enough doubt that's casted in relation to the legitimacy of the cameras, the body cameras, the legitimacy of the injuries in which were caused if he was to have been hit, then the aspects of the illegality of the illegal actions in which he took to open up your car door in the first place, right? If there's no recording being said, you could have literally been saying, in my mind, for all that we know, hey, please get you a sergeant out here immediately. Get your sergeant out here immediately. I'm not getting out of the vehicle. I'm not opening the door. I'm not giving you an ID till a sergeant gets here. And then he just rips open the door, right? So this whole aspect of what happened on that front end, nobody knows. There's no audio. There's no camera. He can say,
Well,
one thing.
I know.
I know you know, but we don't know, and the jury's not going to know. So it could be anything. Even if you know in your mind, it could be something else that you want to make up, because only you and him know. There's only you and him that know what was said.
Right, but I don't make anything up, so
Okay, I'm hearing you on that. I'm just saying the jury, it could be anything. And the lawyer could say, well, I'm not going to say this, or I'm not going to say that, and we're going to say it's this, or we're going to say it's that. You got so many different aspects here of play because there's no audio. And that, again, leads back into without a reasonable doubt, right? We know for certain. Well, that's not going to be able to be the case here. There's going to be a lot of doubt that's cast. And the biggest doubt is going to be the aspect that where's the damage on his face from being hit? Or was this just...
why isn't he dripping blood? And how come his hat stayed on through the whole thing if I hit him so many times?
Well, it's not only that. It's just if the damage...
It doesn't make sense. Sorry.
It's okay. If damage was caused, where is the damage visibly that we can see? All right? If damage was caused, why are you walking around for 5 minutes, 8 minutes, sitting here speaking, getting a conspiracy going on everything that y'all did before you actually go and search the vehicle and do all that stuff? You explained it, and now all of a sudden you're dizzy. Oh, now I'm dizzy. Come on, bro. So it is very weird, and there are some things that can be cast out with the right questions in trial. It's just gonna make me wonder, why are they trying to? You say they're like trying to rearrange you or something like that. And you don't have in your state? Do they do true bills or do they do indictments? How do they do it?
It's an indictment.
Okay, so do you have?
Well, actually, no. I put what they sent me in a PDF in the Discord right away, and
Okay.
there's something marked on the very first page about. I don't remember if it was marked a true bill or not. I can pull it out.
Okay. Well, we'll go over that. We'll just go over that individually then. All right, Wallace, I know you're in and out real quick, so do you want to ask a quick question before I get into some more deeper aspects longer, or are you just chilling for a little bit? Oh, ask to unmute. Ask to unmute.
Unmute.
There you
I'm
go.
just going to chill for a second.
Okay. You just chilling? Nice to see
Yeah, I'm
you.
just going to listen. Yeah, man. I'm trying to learn, as much as I can.
Yeah. Okay. So then, actually, let's check out. Wallace, where did you send me your video at? You sent me in an email?
In an email, and you put it in Google something.
Let me see then.
The one for the state trooper
Yeah.
here in Florida. Yeah, you put it in Google.
What do I
Meet
search up?
or- I don't. I have no idea.
Email.
I know. I think I texted you some things too.
Bro, what's your email?
chiptrainham@aol.com.
Okay. Let me see.
Damn. They're coming for me. Listen.
Chip. I don't know if it was. Is it this one? Chip.
I sent you some for Volusia County Sheriff and State Trooper. The last ones would have been for the State Trooper deal.
I just can't remember.
And then we made
Chip.
a video. Remember we made a video about 4 or 5 days ago?
Yeah, I just can't remember where Chip. I think you sent me. Boom. Let me see if it's under this one. Nope. And then let me check my other email. Chip. Trainer. See, I ain't got no videos in this one though. Chip. Download video. Oh, I think this is it.
And I also sent you dash cam footage that came through an email that I could not open, but you opened, but it was real hard for you to open.
Oh yeah, that's right. I
Remember that? I don't
Yeah.
know where you put it, but that is from State Trooper because it told me I had like 15 days and it was going to delete itself. So you copied everything and put it in a zip folder, I think you called it. So winter, if I go to court,
Oh
I need
yeah.
to know how to open that and show the judge. But anyways,
I need to
well, you
rename
put
it.
it.
Chip.
Yeah.
Keep. Okay, I re-downloaded it again. It wasn't a zip file. Okay, yeah. Okay, it's downloading right now.
Yeah.
Hold on.
So
I don't
the other
remember.
thing to add to that, was there a his call log? Was he on a call? That was the other thing I don't think you could open, because I need to know if he was on a call going somewhere. First off, he should have been running the speed limit unless his flashers are on, but no flashers are on. He was doing well above 95, 100 miles an hour.
Yeah.
He should have been running the example for all of us that are either traveling or driving. It
Right.
wouldn't matter.
Right. Chip. And then I need to move it to Operation Wisedome.
We
Cool.
can speed. You don't. So get out and get the F out the way.
For real. This is Wallace. It might already be in here. It is. Yep, our video's in
Okay.
here. Okay, so which one is it that I need to do? This one? Okay, and then share. Where's
How do I go back? Oh, there we go. Now I can see everybody.
move this down? I got too much stuff open right now.
Yeah, sorry for coming in late, but I know here in
Oh, no,
Florida.
we're chilling today. We're not super strict today.
Okay. I know here in Florida it's terrible, but I'm hearing it's nationwide. It doesn't matter. Oh, there it is, state trooper. Is that it? Yeah, because there's that car hauler. There's the overpass.
What's that about, y'all? Did y'all see that? Let's watch this one more time. It's so crazy, bro. Watch this. Watch the cars passing and their speed. So that's pretty weird in and of itself. I thought that was pretty odd. David needs to get in here. I thought that was pretty odd. So they jump right behind homeboy. Then we have it to where you can look at the back. It's looking at the back of the back of the car video, and you can see everyone's going up at the same speed. Everyone, including Wallace. And Wallace, go ahead and tell him.
Okay, so we were traveling eastbound on I-4 going towards Daytona, if anyone knows the area. And prior to that, maybe a few miles, a state trooper, I was in the middle lane. He passed me, I was running probably 75, 80. He passed me. So he was doing well, maybe 90, 95. Without his lights or nothing, no hazard material lights or nothing going on, just driving. So I sped up to try to find out his car number. It was dark, as you can see in the video, to find out his car number to, call the sergeant the next morning or that morning, because this was like 4:30 a.m. And by doing so, I couldn't catch him. He was, I call it yo-yo driving. He was speed up, slow down, speed up, slow down. So there was a point, I don't remember, I stopped at like 90, 95, and he was still walking away from me. Then all of a sudden, you can see in the camera, he got in the middle lane and then the far right lane and pulled me over immediately. So the first thing I asked him, I said, why were you doing above 95 miles an hour? I couldn't even catch you. I just wanted to get your information. And I thought I had my camera rolling. It must have shut off at that moment, because he asked me for my license, registration, proof of insurance, and the norm. And I said, well, what crime did I commit? He goes, oh, you're one of those. And I had my window down, I don't know, 3 or 4, maybe 5 inches. It was pretty open. He goes, oh, you're one of those. Immediately put his flashlight under his left arm, like he wanted to grab me. And he goes, put your window down. I said, we're speaking fine right here. I can hear you. So he immediately left. He goes, okay, hold that thought, or something like that. I don't remember what he said. Now, he does not have a body cam, but he had a dash cam, which I think we're trying to review now to get whatever the verbiage was said, but it was something of that nature. He came back with 5 citations. One said he clocked me doing 100. 2, not supporting his driver's license, proof of insurance, and registration. And then because I had my high beams on, because I have a bulb out, which it flickers all the time, he noticed my high beam light on my dash. He wrote me a high beam light at the same time. So he gave me 5 citations. So knowing Cameron, I was like, holy shit, let me see what I can do. So I got the dash camera, and I asked for his call log at that same time period, because if he was on a call, then it was my fault for trying to find out if he was speeding. But again, he had no lights on or nothing, indicating he was going to a call. So in my mind, hey, you're supposed to be running an example. You're doing, I don't know how fast he was going. He was up and down, but above 90 miles an hour, easy. And that was the result of it. So I got a court date in about 2.5 months that I'm getting prepared, and I am prepared for it. But at the same time, I want to gather as much as I can to help my case, because this is crazy. But yeah, that's the long or the short story of it. Craziness, ain't it?
So nothing crazy, but the cop just fucking giving him a whole bunch of tickets just due to the fact that, he's calling him out for his his behavior. You know what I'm saying? Out here speeding, just doing whatever he wants. And so, but like I say, it should be easy. We shouldn't have too many issues with Wallace on this when we just kind of call out the cop for what it is. And then, if we want to do something as far as wasting our time and collecting our fees for having to deal with this frivolous manner, we could do so, because
absolutely.
Again, our time's been wasted in relation to this cop out here acting wild. So,
because I think if you don't go after their pocketbook, unfortunately, the upper management and police departments are not even slapping their their wrist. So if we keep hitting their pocketbook, maybe that will help the cause or the glow across the globe on these officers really either learning their position or their laws, or leave us alone. I mean, I don't know what else to do, but I think hitting their pocketbook's going to hurt them even more, even though it's paid for our tax money, which I think is crazy. But I think if we keep hitting their pocketbook, things will happen a little bit faster. So absolutely, I'm going to go after their pocketbook or purse, whatever they use.
Well, if that's the case, then we need to go after their pocketbook individually, in their individual capacity, right?
Well, yeah, if it's, whatever I can do legally. Look, I'm a law-abiding citizen, and I do, most of the time, I try not to speed, and I try to do what I can. I actually have a Class A license, so half the time I am a driver. The other half, I'm just a pedestrian rolling in my vehicle. I'm not driving, I'm not working, I'm just traveling. So I have to play that line very carefully because I actually do have a Class A license, and I work with a limo company. That's what I'm doing now, but I got time to be on the phone. So, they could always say, well, you have a Class A license, and kind of hit me that way. But at the time, I was going to work in my own private vehicle. So if I can hit 2 pocketbooks, their retirement, whatever it takes to resolve this, that's what I'm looking to do. And I'm not an evil person, but I just want to be left, and just like everybody else on this call and millions out there, we want to be left alone. If I was robbing a bank or murdering people, I could understand them coming up on us the way they do, but it's crazy here in Florida.
Yeah, people are getting it down there in Florida. Like I said, cool. we got another guy right now. He just got hit with an injunction, and that injunction's been against him for quite a while now. And yes, in September at least, his wife put it on him. Don't know who had. So he ain't been able to go home. He ain't been able to get his stuff and property. Talk to the kids. Like, the injunction hit hard, and that's what I'm saying. Like, now that we done figured out these injunctions and how they work, it's crazy to see that someone has come to us in relation to an injunction getting put upon them. So we see firsthand how powerful these injunctions are. David, what's up, bro? You want to come up and chit chat for a little bit?
Yeah, I can. I'm here.
Yeah, so I was working actually on yours yesterday.
Yeah, I gotta check it out still. But
okay, I don't know if. Hold on, I need to make sure my participants are open so I don't forget to admit anybody. Yeah, I was working on yours yesterday, bro. And the only thing I was thinking was, do you not want to strengthen up your statement of facts a little bit, or do you want to just leave them like how they currently are?
Well, I haven't seen the newest version of it, but I'm good. I'd like to have it as strong as possible. So.
All right, so let me see here. Let's actually take a look at it for everybody, because this is a good something good to go over. I'll move my zoom over here. I need to make this smaller. Now, David's got a very interesting situation. If y'all are not familiar, he got raided for leaving some jury nullification pamphlets at the local courthouse, and they illegally came to his house with a search warrant. Has caused a whole bunch of problems just because he didn't do anything but really give some truth out to the people, education, and they attacked him. So he's got a huge case, just due to everything that he's had to go through. Let me see if I do a stop. No, I want here.
Oh,
Take the chat out and take this over, and then
the comment, it was an intimidation tactic. I think it's a textbook deprivation of rights to the First Amendment. They tried to chill my behavior. They wanted to intimidate me from not doing it anymore or not speaking my, exercising my First Amendment rights.
So see, I think this is where federal, it comes now. Okay, so we got 42, 1983, 1985 as well. Comes now.
Yeah, that search warrant application shows conspiracy between a couple, and even the prosecutor was involved with it. I think he was operating outside his official duties, helping the sheriff create a search warrant. And the warrant got quashed locally anyway. And
Okay, so you're coming after, so that's why you're applying the 1985?
Yeah, there's conspiracy, I believe. That's why I'm lumping together the prosecutors and the county clerk that said she perjured herself on the stand, or she avoided it by saying she doesn't recall, but she didn't want to outright lie on the stand, so she said, I don't recall. But she says she told me about a jury trial going on, which it never even came up. I had no interest in it. But they really stretched to get this warrant. I don't think they thought I would just,
leave it alone. Yeah,
I think they really thought they would have me once they got me in jail.
Well, that's what they prey on. They prey on people's ignorance. That's the only way that they can truly win.
That's why I'm 2 for 3. I would have been 3 for 3 on cases, but I had the plea bargain to get out of jail. I did 2 bond reinstatements. The judge was like, no, they won't reinstate your bond. Well, once I took the public defender, next day they gave me a PR bond.
See, because this is what's going on. Your factual allegations thus far, even though the formatting is really good in here, all you'd have to do is click up on this visual editor. You just move this bar over.
Okay.
And then you'd come in here and edit this like it's a Word document.
Oh, okay. That's what I was missing. I edited it in the little side thing, and it didn't transfer properly over.
Okay, so yeah, you have a code editor, which is everything in code. You don't want to get over here and start jacking around with the code.
Yeah,
this
I don't
gets
want
your formatting correct.
Visual editor.
But your visual editor allows you to come in here and act like this is a Word document.
Yeah, that's what I'm familiar with. Cool.
So you got all your tools up here. Okay.
Yeah, that's why I'm buying your book here, Payday Thursday, and one of the autograph copies or whatever.
Bro, you're gonna love this thing, bro.
Oh, I know.
I can't.
Once you bring out a cheaper version, like the soft cover or whatever. I'm gonna get one for the sheriff too.
Okay. So check it out. What we got going on is, see, you've got all the plaintiffs.
Yeah.
And then you got your factual allegations. But all you got to do is, if you want to start adding stuff in here, see, because there's only 8.
Yeah, I've got some, each one I've got to add that since they violated their oath of office, they don't have qualified immunity. They don't have any immunity. They go outside their official duties. And then I'll put case law possibly about that. That's so where
Yeah, so we got to get in here and start beefing this up, because in comparison to your other one I felt like was even more, but at least we got the format down. So we just need to start getting in facts. And what's crazy is that, like, if I show you some, let me see. This is a good comparison right here. So I don't know if I'm still gonna have it. I don't know where it's gonna be at though. Yeah, okay, so this is a good example. Okay, so like, y'all can see this whole screen right here?
Yeah, I do.
Okay, so when I turned in my first complaint, I did not have 114.
Is that what the amended was?
Yeah, well, the amended was 90. But
you amended it.
Yeah, so I amended it. But Yeah, I think I had like maybe like 40 something points. But now, as you see, I got each point laid out. You see what I'm saying? This is just what I typed out, and then of course I made sentences from that. But this just goes to show, you know, like,
Yeah,
that we need to get very definite.
I'll put, you know, everything from the body cam footage, how they snuck up the driveway, parked down the road, went to the wrong house.
See, yours are going to be big paragraphs then, since you got such a long story of everything they did. But it's fine. It'll be cool. And we already got the causes of action in here. So we just need to build it. If you want to get together this week and kind of build it together, I mean, we could build it now, but I don't want to take time from everybody like that.
Well, no, we'll do it. We can do it behind the scenes. I'm done every day pretty early, so by this time every day, your time zone, I'm done for the day.
Okay. Yeah, then we just need to work. We need to work on it. We need to work on it like a Zoom or something like this. So then we can just, pop up.
Yeah, the first one we did a quick Discord call or something. I forget.
Yeah, Discord calls are cool too. I like that. That'll work too.
Yeah.
I like that.
Okay. Yeah.
Hey Cam.
Real detail. But yeah, March 1st is my goal. About March 1st to have it filed and then serve everybody once I get the actual court copy back. I'm still learning the process for the serving and all that.
What's up, Ty?
It's easy. Every time I try to follow you on Discord, I can't find what you're showing on the screen. Could you walk me through how to get to what you're showing there? I'm in Discord and I'm looking for David Slow and I don't see his name. I see a David Rad speeding, but this seems to happen every time I try to follow you, that I can't find what it is you're showing. See, I must be on a different page because on my file, at the top, it shows Quentin case, Cam Hood River, Miguel case, Thomas case, Rob Moan, Brett Toe parked.
Yeah, his is completely private.
So,
but I mean.
Oh, so David, you're in a private format.
David, do you want me to release it for other people to see? I can't hear you.
Yeah, you can feel free to share it. It's all going to be public once it hits Pacer.
Facts. Okay, it's open. You can see it now. Some people have requested to have their channels completely private. And
I see.
For those people, just due to their requests, we completely make them private. Like it's state Florida civil. Y'all won't see this guy either. He's just completely private.
Yeah, I can relate, but yeah, I'm happy to show everything. I'm an open book now.
So I don't know. Was everybody able to watch Luis's situation and see what was going on with Luis this past week? I made a video on it. Yes, no, maybe.
Yeah, I seen him. That's what I do when I'm stocking shelves. I'm listening and watching.
Yeah, he was straight up arguing with the administrator.
No, I haven't seen it.
You ain't seen it?
That's a slow watch for me. I got to stop every few minutes and absorb what he's saying. He says so much.
Wasn't following process and procedure, calling it a mistrial. No, you're not at trial. You can't call it a mistrial. You're at
32-3-3. This is set on for a status conference. We are set for trial on the 19th of February. Mr. Ochoa Ibarra, are we proceeding to trial on the 19th?
I'm Luis Ochoa Ibarra, just here by special appearance, and I'm here under duress and under threat of arrest. I was pretty much wanted to call mistrial. I have you guys.
But wait a second. Did you hear what the judge? What did the judge ask first, y'all? What was the first question? Are we proceeding to trial?
Yeah, ask for trial.
Yeah, are we proceeding to trial? Right then, I'd have been like, no, sir, we're not going to be able to proceed to trial at this point. I need to go ahead and get the discovery. I don't think I need to compel. Of course, I can give you a notice here, but we're also going to have to set up for an evidentiary hearing. I'd like to see when y'all would like to do that. Last week you asked me about that. You asked me about, getting from us being, of course, taking my motion to dismiss on statutory framework. So I've went ahead and reformulated that, put it into a notice and demand on unconstitutionally as applied in that constitution framework as you've requested, as far as points of authority as well. So I just wanted to give that file that today with both of y'all. And then we're gonna have to push out trial. There's no way I'm gonna be able to get everything that I need to get done. As far as we gotta have an evidentiary hearing. We gotta get an evidentiary hearing and see what's gonna be suppressed or it's gonna remain. And I think honestly you're gonna have to look at this notice and demand. I think you're gonna after you see this, you're gonna have to dismiss everything. So we'll just kind of go from there. And there's also a proposed order that I'm gonna be submitting with that for you to sign off on. That's how I take it, but
Be right here. Of why, the reason why this is a mistrial. I don't know if you could give a copy to Christensen and also to the judge.
Well, this isn't anything that we're going to consider today. We don't.
It's gonna have there's a mistrial, all right? So it has to be considered. And
there is no mistrial. We haven't had a trial date. Again, if you want to file a motion, you can file a motion.
Let me read to you why this is a mistrial. Well, or not why, but what a mistrial is defined as: a trial that has no legal effect with regards to no one or more of the charges brought against the defendant because of some serious error or prejudicial misconduct in the proceedings or a hung jury. Mistrial can occur in both civil and criminal cases. Federal Rule of Civil Procedure Rule 26.3 states that before ordering a mistrial, the court must give each the defendant and the government an opportunity to comment on the propriety of the order, to state whether that party consents or objects, and to suggest alternative. There is no set time requirement for when to make a mistrial motion, but the movement should generally request a mistrial immediately after the grounds of doing so appears, to avoid waiving the issue, to allow the court the opportunity to correct the error before it can have prejudicial effect if possible. So you have to go through it. But this is the reason why. So on page 2, there's 3 elements to a cause of action, right? And these 3 elements have not been proven.
Okay, Mr. Ochoa Ibarra, today is a status conference. Again, if you want to file a motion,
It's not a motion, it's an affidavit.
We're not addressing this today. You can file this and note it properly. Today is on for a status conference. Your trial is set for February.
There's a mistrial, though.
Are you going to trial on the 19th or not?
There's a mistrial. We can't continue if there's a mistrial.
You haven't filed any proper motions. Are you going to trial on the 19th?
It's not a motion. This is just an affidavit.
Hey, Mr. Christensen, is the state ready to proceed to trial on February 19th?
It's ready, Your Honor.
No, I don't consent. I don't consent to it. You guys have to, there's a mistrial here and there's misconduct being done right here in this court. There's 3 elements to a cause of action. You guys haven't
Mr. Ochoa,
you guys have not.
You have not filed a motion. I'm not going to.
You don't have to file a motion. This is an affidavit for discovery.
We are.
And for a cause of action. This is the 4th, the 6th
file
Amendment,
a
where it says that
motion?
you have to state the nature and cause.
Okay, we're setting your case for trial on February 19th.
You can't proceed. I don't consent.
Okay, then you've made your record. Trial is proceeding on February 19th.
And there's
We're gonna
mistrial.
have another status
Mistrial.
conference on the 18th to determine the order.
Can't continue.
We'll go.
Can't continue with the mistrial.
Mr. Christensen, do you have an order?
he says, okay, well, I guess we're going to proceed, and we'll have another status conference hearing on the 18th to see how everything is going to go. So he said it again. And at this point, what I had to do was really get my boy on point. I had to really sit him down and be like, yo, are you done playing around, bro? And he's like, well, I'm not playing around. I was like, well, why do you keep going to doing this other stuff? And, putting yourself in situations to where, like now you're looking bad. Essentially, you're looking bad in the court because you're now arguing. You kind of had this guy on your side, and he's been saying, like, I feel for you and your family, and your kids are so well behaved, and he just kind of goes off and then he's like, well, I'm gonna recuse you. And then so my whole thing is just like, well, what's going on? How do we fix this? Right? Like, what are you going to do to fix this? Like, what do you want to do? And he's like, well, he has to listen to my affidavit. And I'm like, bro, you can't just go in there and just throw an affidavit around and not. Like, he had everything set. And so I kind of went over that earlier this week in a video that's called The Yellow Brick Road. But I just want y'all to understand how important it is to have an action, to be several steps ahead when in any situation that you're going to, like several steps ahead. Like anything, even with me right now through my arbitration and mediation that I'm about to go through with my client that breached our contract, I'm already several steps ahead. I'm so steps ahead, dude has changed what he's had to send me as far as a formal notice of termination 3 times because he knows everything is not going to work. Everything that he's done cannot and will not work. So, everything. So, an action plan for the motions and filings is very, very important. Hold on one second. Hold on. Gotta check on my kid.
Yeah, I gotta be a dad first.
Yeah, I thought the judge was leading him there to file a motion. It seemed Louis just blew him over there.
Yeah, the administrator was working with him and telling him things he needs to do, and then he goes off and ignores what Cam was going to direct him
on. And I think he had a motion right there. That was like a stack of paperwork he could have filed.
That's a slap in the face to Cameron. Like, come on, bro.
Well, I told Papa Bear, I said, hey, man, you really got to start. Like, I'm putting the time in to help you out and do everything, and you keep going off on these tangents to try and say, well, they have to do this and they have to do that. And it's like, why are you trying to...
They don't have to do anything.
Why are you trying to stop the court, first off? Why are you trying to stop all the evidence being brought forth? Why are you trying to stop making them look stupid as hell when they violated you completely, bro? Like, you should be so happy that you're getting an evidentiary hearing, that you're getting all these aspects and that they're not just completely dropping it on you where you can't be able to get these type of hearings. Because when you start to ask the type of questions that are legitimately, that are the best type of questions to ask, bro, like, you really are tying them down to look so poor in everything that they've done against you and your family that it's just building the evidence for your civil case. And it allows the judge to finally look at everything because the judge ain't watched the dash cam footage, bro. The judge don't know what happened other than what's wrote on the paper. Nobody's paying attention. The judge got too much to do. Nobody's watching that yet. That's coming up in trial or evidentiary hearing where we're actually going through these things. So that's what I'm saying. The evidentiary is going to be fire if he can get his mindset right. And it took me a good hour and a half, 2 hours just to get Luis off of the aspect of trying to go to other ways of just like, he already knows the injunction, but it's like, he knows this. He knows the dude asked to get the constitutional framework as applied, notice to dismiss. He knows all this, but he went in with an affidavit this week, and I still don't understand why. He told me that's what he wanted to do, so I gave him an affidavit, but I didn't know that was all that he was doing. I thought he was filing the affidavit with the notice and demand as well, and he just went in with the affidavit. And then when he, so yes, I'm very confused on things. But it is very important to follow the process and go through the process. Because at this, where he was at now, he should have, oh shit. Continuous? Oh shit, that's way big, bro, chill. At this point where I thought we were at with him was that he was to refile his CR 8.3 motion to explicitly comply with the judge's requirement for a notice and demand style pleading. This time to focus on the detailed constitutional arguments. The violation of the Fourth Amendment, which is the unlawful search and seizure when he said, hey, I don't want to give him ID, I ain't committed no crime. And they're like, hey, if you don't give me up your ID right now, you're going to jail. There was no crime. He's on private property. That's totally in violation. He wasn't moving. The car, there's no moving violation, okay? You may observe something that you want, but homeboy, actually, just like we have a process in the court, so does the police. The police should have waited until he saw Luis leaving again, if that's how he felt that he needed to stop him. But he didn't. He came up while Luis was parked out of the vehicle on private property. Once homeboy says, I don't want to talk, you can't just go in and be like, you have to talk to me or I'm taking you to jail. That's not how this works. Fruit of the poisonous tree. Get it all out of here. It's all suppressed. If you really want to get down to it. Violation of due process, 14th Amendment, of course, Article 1, Section 3 of the Washington Constitution, and then the invasion of privacy, of course. Facts supporting the prejudice, of course, how the law enforcement's arbitrary or improper conduct materially affects the ability to even get a fair trial because of how they judged them right off the bat. Legal citations, and then the format, the defendant's renewed motion to dismiss for unconstitutional grounds. We already did that. That's already in the Discord. Everybody can check that out. Motion to compel discovery, since they haven't given it up yet. I mean, you would think that if Christensen's touting, we're going to trial on the 18th, 19th. Well, where the fuck is the discovery? Why don't I have it then? That's what I'd be saying right there on the record. I'd be like, Judge, Your Honor, he's saying we're going to court on the 19th, but I've yet to see any discovery whatsoever. Do we need to compel him right now? Do I have to sit here and ask for it, or is that something you already know you're supposed to provide, Christensen? Right there in the courthouse. That's not exactly how I'd say it. I'd be nice to it if they were going to take me this far with it. Then we go into the criminal rule CRR 4.7, which requires broad disclosure of material within the prosecuting's authority and possession or control. All that I know that's been filed is, if I bring this over, let me come up to Luis's thing. He said homeboy just filed this or sent this to him the other day. I take this out of full screen though, huh? Oh, well, it's right here then, I guess. Okay, so they just sent this to him, 5th, and it's a memorandum regarding the Rule 3.5 hearing and admissibility of statements made by defendant. Oh shit. I wish this was just automatically on. Oh, jeez, bro. Okay. Comes down to the state of Washington, Biden, through its attorney Paul Christensen, Steves County, respectfully submits the following memorandum points of authorities in opposition to the defendant's second motion to dismiss. Well, damn, that took y'all long enough. But, facts. See statement under penalty of perjury, Feldner, which is attached, attachment A. Argument. Miranda warnings are only applicable when an individual is subject to a custodial interrogation. And defendant is in custody if his or her freedom of movement is restricted to the degree associated with a formal arrest. State versus Post. Amended by, citations omitted, interrogation involves express questioning, as well as all words or actions on the part of police other than those attendant to arrest and custody that are likely to elicit an incriminating response. If a defendant is in custody and subject to interrogation, statements made by the defendant are only admissible at trial in the prosecution's case in chief if the prosecution can prove a voluntary waiver of Miranda rights. So he's given their theory on what they're going to try and say as far as he's voluntarily talking and or he's voluntarily waiving his rights when he says, of course, you know, you can hear, I'll show you right here. Do you want to see? Open my door. The court must look to the totality of the circumstances, including the setting in which the statements were obtained, the details of the interrogation, and the background, experience, and conduct of the accused. The United States versus Carroll. A waiver may be in writing or oral. Validity of waiver is not dependent upon signed or written waiver form. On October the 6th, approximately blase, Feldner was at Spoko, black truck pulling on a trailer. He noticed the trailer didn't have plate, appeared to be false plate on the truck. Detective Feldner stopped his vehicle and approached the defendant, who had gotten out of the driver's seat by the gas pump. Detective Feldner did not place the defendant under arrest and explained that Detective Feldner did not place the defendant under arrest at this point, but simply explained that there was no plate on the trailer and asked to see the defendant's driver's license. The defendant said that he was not doing anything illegal and refused to provide driver's license. Officer Smith arrived on this as defendant's license came back with no record. Defendant Feldner attempted to determine that the vehicle's ownership by running the VIN was partially covered. Deputy Lee arrived after running the VIN, finding coming back entirely different. Feldner again requests identification. The defendant continued to argue. I don't know what motion he's responding to here, because that can't be the only point that is in here. That's crazy. Yeah, that's wild. Okay, but apparently that's it. That's all the response that homeboy got. And it says that as there was no custodial interrogation, the statements made by the defendant to the deputies are admissible under CRR 3.5 State Point Post Super. Which I don't even see how you can say that, due to the fact that, again, homeboy said, from the very beginning, I don't want to give him my ID, but it's only under duress. So
I never heard Miranda either.
Yeah.
In the whole video, I didn't hear Miranda. So since they didn't give him Miranda, all jurisdiction ceases. Is that right?
Well, it's definitely an issue because they didn't read them whatsoever. It's just to the extent of how we can explain it in a way in which, again, with the right statutory framework, to apply directly for the court to go and grant. So, like, if I say we're going over and looking at like Luis's, if we're coming over and looking at Luis's,
Hey, so I have
They
a
didn't
question
read me
about.
my rights either. Sorry.
That's right. I have a question on Miranda rights. I was going to call you later, Cameron.
Yeah. There's supposed
So,
to be a few that they're supposed to even read like right off the jump.
all right, so say you're pulled over for speeding or whatever, traffic offense, and they just come up, hey, I stopped you for X. I need your license, registration, proof of insurance, blah, 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 right? And then we start with our speeches or our memorization or our script and start talking to them. Is everything squashed or admissible in court because they didn't read it? Or once they read it, then everything is guilty in court?
It's for a custodial arrest.
I know, but
So-
I'm still confused because when I read it, so if they try and arrest you or put you in handcuffs before they read it, it's an illegal arrest then, correct?
Well, they're supposed to tell you, yeah. Yeah, they're
All right,
supposed
so if you go, you start talking with them, saying, "Hey, I wasn't speeding. You don't have no jurisdiction over me," and all that, and they never read the rights to you, and you're talking with them. Is everything that you said between that officer squashed, doesn't go to court, or can they still use it against you?
Well, okay, so you can call for it. If there are certain aspects, yes, so you can get it completely suppressed. And the reason being is because they're supposed to read you those things and give you the warnings of the rights that you have. If they're not explaining those and bringing those forth, and you just freely share that without them first giving you, again, those Miranda rights being spoken, being announced, then yes, everything from that point further, or from whenever you're requesting it, can be suppressed in that aspect, yes.
So you could actually say, "Hey, I did rob the bank and shot somebody." Then they read you your rights. They can't use it against you.
No, not necessarily.
No, okay. Because that's confusion in my mind.
Because now what you're doing is you're reaching to say that there are not other circumstances or contexts around the circumstance to be able to prove that you did do said thing.
Okay.
You know what I'm saying? So your statement alone does not make the charge valid or not. The context of the overall.
Okay.
What evidence do you got, baby? The statements alone do not suffice just in and of itself. It's the whole aspect of all the evidence, right?
Okay.
Hitting you and then you don't say anything, then they have to give you your Miranda rights. But if you just openly say, "Hey, I shot and killed somebody," then they didn't have to ask you for it. You just gave it to them.
Mm-hmm.
Well, what's the difference between? I know the big difference. You killed somebody, but I was speeding, or I followed you doing 95, and now you're telling me I was doing 100.
Yeah,
that's what happened in my state trooper case.
The first thing they're gonna do is, "Hey, do you know I pulled you over?" And you go, "Oh yeah, I was speeding." Well, you just voluntarily gave them what they were looking for. They didn't have to. You didn't have to give it to them. You could have been like, "No."
Okay. Gotcha. Well, then I'm going to have to work on that with you, Cameron, because that's the first thing I said. I said, I was just curious why you were doing north of 95, and I still couldn't catch you with no lights on. And that's when he said, "Well, I need your license, registration, proof of insurance. I clocked you doing 100. First off, you were in front of me, so you didn't clock me. And you were doing a yo-yo driving, which they were speeding up, slowing down. And then when he finally, from the dash footage camera that they gave us, we were all running like 75, 80 miles an hour. So we weren't doing 100. So if he's going to use that for in court, it looks bad on him. That's how I think. That's how I look at it. But I could be wrong.
That's an open conversation. So, like, if they start asking you questions, like right off right off the bat, then you can be like, "Well, no, I have rights." And if they still keep asking you questions and stuff like that, and you still go on about your rights, then that's a violation. Then they should be giving you your Miranda rights. If they don't, then anything said before that is gone. But if you just have an open conversation with them and you're answering all their questions willfully, and there was nothing, like it was just a normal conversation, that's all gonna go against you.
So, what is it called? Go something? I can't remember.
Your Miranda right. Is that like? If I'm wrong, Cameron, let me know. But I kind of think I got the gist of it.
Conversation.
Okay, cool.
Yeah.
I just wanted to say I got arrested 4 times last year. Stupid to say out loud, but 4 times. And I heard 0% of any so-called Miranda anything. Any of those times. So it's not a thing. It's something nice to talk about, but it's not a thing.
So how are they getting away with this, especially if they have body cameras and or dash cameras recording this and it's caught on video? Are they deleting this shit or what's the deal?
Well, there's a particular doctrine that I've become aware of.
Okay, well.
You have to invoke
Hit him
your
with
right.
it, man. Hit him with
Remain
it.
silent.
What's that?
You have to invoke your right. So, like, it's just like the right to remain silent. You can't just be quiet and not say anything. If they keep talking, you're like, I'm just going to invoke my 5th Amendment. I want to talk to my attorney. You know, and then that it should be just null. Everything after that should be null and void. You invoke to plead the 5th. So, but you have to say, hey, I wish to speak to an attorney. That's enough, you know, for invoking your right. If you don't do that and you just engage in a conversation, then it's open information. They don't have to. That's how they get you. Those are the tricks behind it. If you just voluntarily give up information, that's why they say, don't talk to the cops. Don't give them their information. Say you want to talk to an attorney. If they start asking you questions, you don't have to answer any questions. If you answer questions willingly, it's open. They got you.
Okay.
You
so the first thing you have to say is I revoke my rights, or I want to discuss it with my attorney.
Don't revoke your rights.
It also depends on the situation. If they're like, hey, do you know why I pulled you over today? You're not necessarily you don't necessarily have to invoke your 5th Amendment right. You could say, no, I don't know why you pull me over.
Okay.
And engage in the conversation that way. But anytime you admit to guilt, you're admitting to it, and it's open. Right. If you don't understand why they pull you over, you don't answer questions. You have to be.
Good question.
Gotcha.
Yeah,
Okay.
how they
Understand.
on me is so I invoked some rights, and then they just reached through my window and put me in handcuffs, and I was arrested.
Right. So if that's documented, if you have that on a recording, whether it's your phone, their body camera, which is why you can pull their body camera, and you should, that's how you can engage in your defense. If you didn't read into it, or if they didn't read you your Mirandas, you can go after them for it.
They did that, except in court, when I asked the officer why there's no audio. Oh, well, we have a policy, you know. Huh, okay. You know, and then the judge sits there and tells you, oh, okay, well, see, clearly you committed a crime. That's a crime, you know. It's unbelievable, man.
So check it. Yeah. We've gone. Did I? I think I already did a video. Maybe I didn't. I think I did a video on Anthony's situation. This is Erica. We finally got Erica's police report. So let's go through this bad boy. Narrative. On 11/3/2023 at approximately 100 hours, Erica was placed under arrest for aggravated assault on an officer and resisting arrest after she struck an officer in the head with a metal crowbar. The officer had conducted a traffic stop and traffic-related violations and was conducting an investigation when the assault occurred. Montgomery was transported and booked into the jail. I was conducting a routine patrol when in my fully marked vehicle fully marked duty uniform, eastbound. Notice silver Honda traveling. Number 2, displaying registration tag from 2021, expired. 2 years ago, I ran it, which returned expired, and also the plate was suspended for no insurance. As I was collecting this information, I noticed the vehicle was not slowing for an illuminated yellow traffic. The signal turned red, still red, approximately for 4 seconds. The vehicle showed no signs of slowing. She got pulled over. My newly issued body, okay. I immediately illuminated my overhead lights and proceed through the intersection. The vehicle came to an immediate stop. It should be noted. You better note it, homeboy. It should be noted that while my vehicle's front-facing camera initiated upon the activation, my newly issued body-worn camera did not initiate due to unknown technical error. There is no audio on any of my video, and the body camera did not turn on until I initiated it later in the contact. I was unaware of this until I realized my body-worn camera was not recording, at which time I immediately turned it on. He's got a Brady complaint, right, Erica? I think so. As I approached the driver's side window, the female rolled the window down approximately 3 inches and stated she was sorry for proceeding through the red light, indicating she was aware of the red light signal and knowingly proceeded through the signal. She stated she did not want to make an abrupt stop due to her car being loaded with personal effects, which may have been hazardous to her and her belongings.
Did he say he turned it on? Because at no point did he turn it on.
I could see she had a large amount of miscellaneous personal items and clutter in the vehicle, but nothing seemed to be placed in a manner that would have been hazardous. You could be talking about your urn. I asked her what exactly would have been hazardous to her, that she stated she had books on the floor of the vehicle. I asked the driver for a license, registration, and proof of insurance. She produced a valid Arizona driver's license and identified her as Erica Montgomery. Montgomery stated she had not registered her I didn't see you hand him anything. She had been in the process of moving over the course of the last 2 years. I advised her that was not a valid reason for her registration. The required registration. She did not have a permanent address. I asked her again for the proof of insurance. She stated she doesn't have any and insisted she is not required to have insurance to operate her motor vehicle. You're right. Well, it's not. First off, it's not a motor vehicle. It's your personal property. I informed her that was not true and asked what would. Man, you could honestly hit this dude. For the the red light thing's. Okay, well, he's still terming you.
I've been rear-ended 3 times before. I'm not gonna I knew someone was behind me. I did not know it was a cop.
So I informed her that was not true. She was involved in a collision with a vehicle or person when she went through the red. But you didn't. So again, you can't be utilizing something that didn't happen.
No, but I have a fear of it. I've been traumatized.
I'm talking about him. No, I'm talking about him. He's trying to utilize. Someone could have got hurt. And that's not how this country works, is what I'm saying.
Yeah, there was no one waiting to go through
at all
in any direction.
No, yeah, you were clear. Pay for such things. I advised her that her license plate was suspended due to her either not having insurance or her insurance lapsing in the past and was not providing the MVD with current insurance information. She again insisted she was not required to have insurance and stated she had not been made aware by the MVD that her registration was expired or her license plate was suspended. Hey, it's a good excuse right there. I advised that the registration was expired or her license plate was suspended. I advised her I was required to collect the license plate per state statute.
He didn't tell me that.
Okay, well, he's stating that though.
I know, of course, just more lies.
Yeah. She responded by telling me I was not taking her property. I informed Montgomery I was going to write her a citation for the civil traffic offenses and collect her license plate as required. She became extremely agitated and stated again that I was not going to take her property. Based on the statements Montgomery was making, such as not being required to follow state law or subject to fees imposed, let's just say follow state colorable law.
He's making all this up.
Or subject to fees imposed by the state, as well as other behavioral cues. I guess that was supposed to be clues. I recognize Montgomery likely aligned with sovereign citizen ideologies. Okay, well let's do this. since you've brung that into it, you've shown us that you're being biased, and you're being biased in things that you have no clue about.
And he's also making like, he never said he was going to give me a ticket. I got that ticket when he's fucking lying.
So right here in Joint Resolution of 1940 under Chapter 183, you have whereas some 2 million young men and women in the United States each year reach the age of 21 years, and whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic, therefore be it resolved by the Senate and House of Representatives of the United States of America in Congress assembled, that the third Sunday in May each year be and hereby is set aside as Citizenship Day, and that the President of the United States is hereby authorized and requested to issue annually a proclamation setting aside that day as a public occasion for the recognition of all who, by coming of age or naturalization, have attained the status of citizenship, and the day shall be designated as I am an American Day, in which they are to, either at the time of the rendition of the decree or naturalization, or at such other time as the judge may fix, the judge or someone designated by him shall address the newly naturalized citizens upon the form and genius of our government and the privileges and responsibilities of citizenship, it being the intent and purpose of this section to enlist the aid of the judiciary in cooperation with civil and education authorities and patriotic organizations like this one here, in a continuous effort to dignify and emphasize the significance of citizenship. Okay, so when they be calling you sovereign citizen, they really don't even know what the fuck they be talking about, because sovereign citizens is like the highest of our self-governing republic. That's the context within what sovereign citizen means here in America, that they've taken away from us for some reason and indoctrinated people like this cop here to think that taking sovereign citizen ideologies is somehow bad. Actually, no, sir. It's sovereign citizen is actually the highest term within our self-governing republic. So I don't know what they be talking about. Based upon my training, your poor training. So thanks for telling us that. Where were you trained? We need discovery. I need to know where this officer was trained. Where was you trained? Who trained you? Where did you get your certification? How long of training? I need to know all the details.
Manal.
And your experience with sovereign citizens. You wanted to bring it in here now in your motherfucking incident report about your experience with sovereign citizens. Well, let's do it. Since you want to bias Erica, me, as being a sovereign citizen, and based upon your illogical training, your biased training, to where they haven't given you proper education, let's bring all that in too now. Since let's talk about your experience. That's great for evidentiary hearing. They are often extremely argumentative. Well, that's probably because you're thinking that you can come in and tell people what to do and they're just supposed to abide. Thereby, you're over here violating people's rights, their due process, blatantly. Like, you just out here with your presumptions running around crazy. That's not acceptable. Can often be extremely violent. Oh, now you're utilizing a false ideological term in your mind because you're not well educated to know that other people are violent, which means now you're utilizing that ideology to put her into the placement of your illegal actions that we're about to go into. He's setting up the story, which allows you to give a good evidentiary hearing to get the questions out on or to him. Man, this will be good because he's gonna have to explain himself, and those questions can make him look very stupid, and are known to be often to be armed. Due to this, often to be armed. So you're saying that we aren't allowed to be armed? Isn't that part of what you know?
Everyone's allowed to be armed.
Yeah, like, what are you throwing that in there? Like, that's some bad
He's
thing.
the one who's armed.
This dude's tripping, I know. Due to this, I called for a second officer to come to my location for extra security. Due to me eventually needing to be in the rear of the vehicle to remove the license plate, I asked Montgomery to step out of the vehicle. Due to her statement and demeanor,
Now stop right there. Again, right there. Now, this doesn't make sense. He needs to be in the rear of the vehicle. So why does she need to step out?
Right. He's setting precedent. He's setting the story.
I don't understand.
Setting the story.
I don't understand why she needs to be out, because he needs to be at the back of the car, at the rear of the vehicle. That totally doesn't make sense.
He had no reason. When I asked him why he wanted me to get out, I said, "You don't have a search warrant. Why do you want me to get out?" And then that was when I said, "You're making me nervous, and I'm gonna get my phone now." And I looked right at him while I was reaching for my phone, and that was when he lunged forward and opened the door.
Wait, we're not there yet. Wait,
we're not there yet.
Okay, step out of the vehicle. Due to her statements and demeanor, I believed placing myself at the rear of the vehicle with her still in the driver's seat placed me in unnecessarily dangerous position.
Oh, that's why. Okay.
As she could easily back the vehicle into and over me very quickly. In addition, I would not have a good view of her as my attention would be fixated on the license plate screws and bolts. Based on these facts, I asked Montgomery to step out of the vehicle for my safety.
Well, can I make a point right there?
I was going to make one too right here as well, but yeah, you can follow up. Just he could have just easily waited till backup arrived if you've already called it, as he stated earlier in his statements here. Go ahead.
Right, but I see that the Patriots, we do the exact same thing when we say, "Oh, he's walking up with a gun, so now he might shoot me." See, it's not really true. The whole perception of our mind. We don't want to go there. We don't want to say he's got a gun, so I'm scared and I got this and that. No, he's there to protect us. Just like he can go, "I'm going to go to the back of the car." Why would she back me over me? Why would she do that? That doesn't.
Because she's a sovereign citizen, Zeke. She's a sovereign citizen,
and he's a guy with a gun. So both sides. We don't want that to happen.
So based on these facts, I asked Montgomery to step out of the vehicle for my safety. Montgomery refused, stating she did not have to and would not. I advised her of Pennsylvania versus Mims. Okay,
he did not.
It doesn't matter though. This is what's funny, is that he seriously in his mind thinks that matters or is applicable in this situation whatsoever. It is not applicable whatsoever. You can mention that shit all you want. You know what you need to be stating in your incident report before you even state that is, "I observed Erica to be shown. I observed an object. I observed a gun. I observed this for threat of my safety." Not the aspect that I need to go to the rear of the vehicle to remove the plates as a threat of my safety, and now I need to pull you out of the vehicle. That's not how this works, bro. That's not how this works, bro. You don't get to say, "Oh, because I need to pull off the license plates, and you could possibly then back over me if I was to do so. If I'm here alone, then that could be dangerous to me, so I need you to step out, because Pennsylvania versus Mims states that if I was to see some kind of dangerous object, such as a weapon, which could cause damage to me, then I can ask them to step out." But the aspect is that he never saw anything dangerous in the car that was threatening or dangerous to him to incite or bring forth Pennsylvania versus Mims, therefore making any requests null and void. And if any attempt was okay, go Zeke, go. You got me from here, Papa. Go.
Let's go back to the facts.
Wait,
let's go back.
The facts are he outweighs me. That's a dark.
It doesn't
parking
matter.
Lot. He didn't show me his badge. He could have raised me.
These facts don't matter.
No, it doesn't. Wait, Zeke.
Here's what he said.
Wait, you gotta stop for a second. Erica, this is what I'm talking about. We just had a good conversation the other day about this. You're going to irrelevant things, and we literally giving you everything right now, going through the best information. Don't argue irrelevant points. Just listen what we got. We giving you the gold right now. If you watch this several times, you're gonna be ready. Zeke, go.
So he says he called backup for his safety. So if backup comes, backup can stand by her window, make sure she doesn't put it in reverse, and that solves that problem. There's no reason for her to get out for his safety. In fact, that would probably be worse. So his whole logic what he's saying doesn't make sense, and you just turn that on him because we go with everything he said. It doesn't matter. He said all these things, and they're not true, but that's
irrelevant. Yeah, it's irrelevant. If it's true or not, it's irrelevant. What he stated, he has to hold to.
Yep.
And if you find patches and holes in those statements, you cause enough reasonable doubt. Then also, you're able to get things excluded. Right here, he has laid out a whole plan of action. So what I'm starting to understand is you go into, well, let's get into policy here for a moment. Okay? Let's get into these are the types of questions and things you're bringing up in evidentiary. And as you're going through everything, as you're going through the process of developing your paperwork, let's go through what is normal procedure. When y'all have, when you've said you've based on your experience, let's ask this, based on your experience, how many license plates have you removed? And in those processes, how many times have you pulled people out of the vehicles? Let's see if he makes up something. Let's see if he answers properly, right? Because if he's answering a certain thing, we need to now see we need to get him to find out what case, I'm talking about, what cases are you speaking of then? Go based on memory. Let's see how you acted. Let's pull up information from there. Like, we get to go deep on those aspects. But you want to cause enough holes and doubts within the whole thing. So what I'm seeing here,
Cam, just a little bit there. The procedure, see, it really isn't done on the stand in the Perry Mason deal. These questions are asked in discovery, so he can answer them on paper, and that's really where you're getting all your information and prosecuting him at the same time. So it's done before the trial. It's before court. It's outside. It's in our court. Discovery is our court moving against them.
Make them prove what they said is valid.
Facts.
Yeah. On paper first.
Yeah, because this dude's, where's the Pennsylvania versus Mims? I can't even find it. I'm so lost. Based on these facts. Okay, there it is. I advised her of Pennsylvania versus Mims, which is a U.S. Supreme Court case allowing law enforcement to remove all persons from a vehicle during a traffic stop due to an inherent dangerous nature of the traffic stops. Okay, there are dead ass elements for Pennsylvania versus Mims, and him just, again, being very overly broad and vague in his application of Pennsylvania versus Mims is not justifiable. That's why I'm starting to think we almost just attack that aspect right there. Was the justification of you invoking Pennsylvania versus Mims okay? No, because if
never said that to me.
Okay, oh my God.
I'm sorry. It's
someone wait. Me or Zeke? No, we gotta both stop talking for a second. Can someone please tell her what me and Zeke have been telling her by us not having to say it, please?
Erica, the facts don't matter. What they did, what they said, doesn't matter if you can't break his testimony apart and do what Cameron is telling you to do. You got to let go of your emotions on this and just hear what they're trying to help you with.
It doesn't matter. It doesn't matter because you can't show it. Nobody's going to be able to show it. It doesn't matter. If you was able to show it, I would be like, fuck yeah, let's go. But you can't show it, so it's irrelevant.
It doesn't matter what should have, could have, or didn't happen. What he said has holes in it, and you can prove that on paper. You can break it down.
There you go. And as an overall perspective, again, on this deal, if we come in and we know these sovereign citizens are the way they say we are, okay, and we want to keep safety, because that's our main concern. How important is it, because really, in this situation, how important is it to get her license plate at this time? Why do we need to do that now? If it's dangerous. So, because who cares about the plate? We get it later. Write her up and let's go to court.
Erica, what they're trying to tell you is use their rules against them.
If they say case law, they have to know what they're talking about. And if you go back to the video that Carl Miller said, you have to know what you're talking about when you reference that case law.
But ultimately, a couple things on the red light, right? And he claimed that, for someone's safety, guessing there's probably nobody else around anyway, but it doesn't matter because they have no duty or obligation to protect anybody from anything at any time. So that's it's all nonsense, you guys. You know, Pennsylvania versus Mims violates the Fourth Amendment. Period. End of story. It's officer safety. With scared of a license plate? What? You know, and if he has backup come up to the passenger side of the car, is that going to really prevent anybody from putting their car in reverse and running somebody over if they really wanted to? No, they're
You
just
think
excuses.
so?
They're just excuses to try to justify nonsense with nonsense. That's it. If you look at my video with the cam covered, he says Pennsylvania versus Mims. I just gave you a lawful order. She was putting her gloves on when she was on the passenger side. She was already ready and prepared to go hands on. There was no reason. If anybody's seen Cam cover my video there, what was the possible reason?
Didn't that cover yours? I thought I did, right?
Yeah, you did. Yeah, on the 100 or the 1,000 marathon. That's what I'm saying.
Okay, good.
But
okay,
And remember, generally speaking, they always tell you to stay in the car.
Yeah.
Well, that depends. If you get out of the car, they tell you to get in the car. If you stay in the car, they tell you to get out of the car. It's what it is. It's so they can just handcuff you, put you in the back of their car, and hey, look at that guy. When we were busy assaulting you and battering you and handcuffing you, kidnapping you,
Policy
left your door
is
open.
to keep you in the car.
Right. You left your door open, so now it's plain view doctrine. So now
So
we can.
why is he asking her to get out?
Right. Exactly.
Right.
And that's the point right there. That's the constitutional violation in which we can stop everything and try to attempt for a fruit of the poisonous tree doctrine. Okay? Try to get all of this excluded and suppressed as far as what happened. You're claiming that I hit you, but that's after the fact that you unconstitutionally opened up my door after requesting that I get out when there's no crime that had been violated whatsoever. So that's how I'm kind of starting to look at it a little more. But we'll continue. Let's go through this a little bit more and see what we got to help enforce our plan of action, our direction, right? And help Erica get her mindset right. So let's see. He's going to say traffic stop due to inherent dangerous nature of traffic stop. She still refused and began reaching for objects around her in her lunge area. I asked her to please keep her hands where I could see them and asked what she was reaching for. Initially, she did not respond, and I noticed she looked to be picking up objects and placing them underneath articles of her clothing and her person. She then stated she was trying to find her phone to call her attorney. I stated I would give her an opportunity. Man, y'all, you should have done that because we'd have got right on the phone real quick. Me or Zeke and been like, yes, this is Cameron Wilson. Yes, I am her attorney. Like what? Like straight up. No, you can't do that. Don't ask her any questions. She's done talking. No, she's reserving. I'm reserving all rights for her right now. She's done talking. You can talk to me. What would you like, officer? What is the crime? No, she's not doing any talking. Y'all want to ever do that? You call me up. You better FaceTime my ass too. I'll be right there talking to him. No, sir. Yep, it's Cameron James Wilson, attorney in fact. How may I help you? Yep, nope, not happening. You're not talking to my client. My client's not giving you any information. We can do that. All right. Initially, she did not respond. Yes. I stated I would give her an opportunity to contact an attorney if she felt that was necessary, but she needed to step out of the vehicle. No, she didn't. And stop reaching for things in her car. No, she does not. She refused and then focused her attention on an open space between the driver door and passenger seat in the van and reached for that area. At that time, Officer Beers arrived as my cover officer as requested. Oh, how convenient that your cover officer shows up right when she's reaching for something. I immediately ordered her to stop reaching for objects in the car and to step out of the vehicle. She then reached for the controls on her driver's side door and began rolling up the window. Now we see why. Now, this is perfect. It's perfect. Even if you didn't, it's great. Why? Because it shows that you're rolling up your window in fear that he might try to open up your car door. And in such, he did just like the other cop did to Hayden and opened up that door. Oh, buddy. You think because I roll up my window, you just get to open up my car when there's no warrant whatsoever for you to search, nor asking if you could search? Your request for me to step out of my vehicle can never be a demand, unless you have probable cause of a true crime that I had committed in some aspect. You don't just get to willy-nilly open up my car door however you see fit. You may be sitting here saying, you took in your mind, oh, I can't really see, but she was reaching around for things. Maybe she was trying to find some documentation to give you finally, bro. Okay? Look, Erica putting pictures in the thing. She all about the facts. I like it, though. I see her. Erica's giving a good story. Okay, I like it. Okay, yeah, she's like, look, this is what's in my car, yo. Okay, cool. I like it. All right, cool.
His argument on the paper doesn't matter. Cam's giving you all your argument you need to go in with. What he said, Cam's telling you how to rip it apart. Easy. Just like, you need to keep going over this and over this. Maybe ask Cam for the recording of this this video afterwards, and then
we'll have everybody have it. Yeah, everybody has it for sure. She then stated she was trying to find her phone, call her attorney. Yeah, the driver, Officer Beers, rock cover immediately ordered her to step out. She reached, rolling the window up. Man, I'm glad he said that. That's actually great. I mean, it works in your favor. Wouldn't you agree, Zeke? Doesn't it work in her favor? You're muted, but I think it works in her favor for sure. It's great.
100%. 100%. Because he's confessing. Doesn't have anything to do with she said or did. Don't matter. He's confessing.
Yep. Rolling up. So he's going to stick to this story, which is great. So I opened the door before she could lock it. Oh, no. Oh, you big dummy. Yes. Oh, that's good stuff. Love it. Just because he said Pennsylvania versus Mims and states that he now sees her reaching, but doesn't indicate an object in which could be dangerous, does not mean that he gets to escalate to the next level. That's not how this works. Just because you don't know what I'm reaching for, bro, doesn't mean it's a dangerous object. You don't get to just willy-nilly, again, violate people's rights. That's not how this goes. You gotta have patience. And these people have no more patience anymore, bro. That's the problem. They have no patience. Let's see. I opened the door before she could lock it, and she immediately lunged for the space between her seats again. In response, I lunged into the vehicle into an attempt to control her hands and defeat the seatbelt, fearing she may have been reaching for a concealed weapon. Well, I'm sure she's fearing that you're about to rip her out of her fucking car illegally. So does your fear more justified, or is her fear more justified? Well, due to the fact that there's no crime being committed, her fear is more justified. Because, again, she's the highest of authority. There is an illegal intrusion into her privacy, into her effects, into her property. She is now being assaulted and violated when there has been no harm. There's no sworn affidavit. There's no crime being committed. This is now an intrusion where there's no justification. And that's where we need to focus on, is the intrusion, the illegal intrusion into your rights without probable cause or a reasonable articulable suspicion of a true crime, which means a verified complaint. You see how it all goes back down? Like, if we wanted to, we could either go the Zeke way of the mandamus, or we could go with an injunction in TRO based on the constitutional violations up front. Should you, as an officer, have lunged into her car without first waiting for your backup to arrive to de-escalate the situation and find a resolution before moving into assault? Because the only time any kind of violence or assault or touching is to really actually occur, apparently, we need to get his training. And maybe we should, because we'll then get his training manual, and then we'll find out what tests he took in relation to hands-on. And then we'll find out and see within that manual, here it says that the only time that you are to initiate any kind of hands-on action within your training, as you've stated within your incident report, is when this occurs. were the elements of him putting your hands on you between what language is going to be placed in his training manuals? No, they're fucking not. Because the only time they're supposed to be putting hands on people is, again, in relation to a true crime. Did they have a warrant to open up the car? Did they get consent to open up the car door to search? Because the moment he opened up the car door and lunged in, that is now a search and seizure without probable warrant or cause of action.
Yep.
But guys,
They're the sovereign citizen.
Don't you
They,
know
they think they're above the law.
Well, that was well put, well run down. I gotta go, but I also wanted to say that I'm so grateful that she had a license, because then it would have been a whole bunch of other crap in there. Because whether she had a license, in our understanding, she doesn't need one, but in their understanding, that took away all his stuff about she's driving without a driver's license, and now we gotta go in for other things. So that the fact that she had the license is gold to me, because then we can talk about what you're talking about now. See, and that's what I found. And not having that license causes a lot of problems in a lot of ways. Not that it's not right or wrong, and that we, but it's just more to handle and more to deal with. So, but now we're getting to what they did and how he did it, and why is he escalating on the side of the road? He's escalating. There's no need to. See, especially because she has a driver's license. There's no need to. Give her a freaking ticket and let her go. And that's their policy. They don't want people pulling them out. He's really confessing there, and a lot of cops are not going to agree with what he did.
Right.
And the judge is not going to agree with what he did.
Right.
So, I mean, it's gold right there.
Yeah.
This is gold.
Yeah, it is gold. This is exactly what I was waiting for. So, all right, you got to go?
Yeah.
You're leaving? All right, well, you enjoy the rest of your day. I appreciate you stopping by and saying hello. We'll talk later. Yeah, everybody say bye to Zeke.
Have a good one, Zeke.
Bye, Zeke.
Bye,
Thank you.
Zeke. Appreciate
I'm
you,
enjoying
sir.
the whole weekend. So
Y'all be good, Zeke.
give me a call if you want to talk. All
Thank
right,
you for
guys
everything.
too. There's Cam's running it down, and it's gold. So I know you guys know that. So keep learning.
Okay, I'll see you later, Zeke. Thanks, Papa. Bye. Okay. So, where we at? As I did, I came to lay across her torso area, facing her, and pressed her body against the seat with my body. Okay, so this is where you said, and I can, excuse me, remember you saying this is when he was putting his elbow, you were on the video saying, this is where he's putting his elbow into my neck. He's just being very, he's being very vague and broad in his explanation, but clearly you got more, specific at the point in time because it's fresh in your mind, which was he laid his body over yours, throwing his elbow into your neck and trying to get control of you, trying to get the seatbelt to unbuckle it. That way he could do his maneuver to then pull you out of the vehicle, right? That's what's happening here. So it's saying fearing she may reaching concealed weapon, control her and prevent her from accessing a weapon or placing the running vehicle into gear. For what? What crime has she had committed for you to do all of this? It makes no sense. Yeah, man, this is fruit of the poisonous tree. We can knock this out, I think. As I was trying to defeat the seatbelt, I could feel several strikes on my torso area that I recognized as closed fist strikes. Your torso area with... Yo, this dude's complaining about his torso area getting hit with, when he's got his vest on. Bro, this guy's out of there. What a whimper. What a whimper. What a whimper, y'all. Okay.
You guys know how hard it is to defeat a seatbelt.
Man, what a
I
whimper.
didn't even have my seatbelt on. Again, another lie. I took it
I don't
off.
know. Yeah, sure did look like you did when you got ripped out the car. You were hooked on that bad boy. Cause I
didn't have it on.
Okay. Well, you was hooked in that bad boy when they pulled you out that first time, and then the seatbelt still hooked on you, and then they finally get you down. You see the seatbelt go back. So it was hooked on somebody. I saw it come out. Okay. Either way. So then
I don't remember having it on.
Okay. I think it hooked on somebody though. And then as I did, I came to, I laid across, prevent her from accessing the weapon. As I was trying to defeat the seatbelt, I could feel several strikes on my torso that I recognized as close fist strikes. As I recognized, nigga. Montgomery was also writhing and contorting her body and twisting away from me. Yeah, you're fucking violating her, bro. As I attempted to control her, making it dip. Why? Why do you need to control her? Why, if anything, why didn't you just open up the door and say, please step out of the vehicle? Why did you lunge in to attack her? Let me ask you this, Officer Blase. Have you ever taken any classes within the police academy going over just primal instincts of humans? No, I've never taken any classes. Okay. Have you ever gone to college for primal instincts aspects whatsoever? No primal. Okay. Let me ask you just your own personal opinion. Have you ever just had instincts to where you flinch or move, or just someone does something to you and you're kind of just like, it's a natural reaction that you don't even necessarily control? Well, yes. Okay. And do you think, maybe possibly this person never having experienced a cop lunging after them and trying to control them in this manner would ever happen to them? And even though it does, that their natural reaction would be to remove themselves away from that if they've never been in this ever before? Well, yeah. Okay, so it gets deep, yo. It gets real deep in relation to just natural reactions of who you are as a living being. You've never been controlled
Fight
before.
or flight.
Yeah, it's just natural thing. You cannot stop that sometimes. It is what it is. Someone's attacking you. You've done nothing wrong. You're trying to defend yourself because you're in fear. I don't care if it's a cop or not. If they're doing something illegally, then you have every right to protect yourself. That is law. That is law. Then I felt a hard object hit my head in my area of my right eye and temple area, in the head of a metallic clang on my skull, inconsistent with a metal object striking my head. I was able to unbuckle the seatbelt, at which time I thought so, but he could be lying too. At which time I grabbed onto Montgomery's clothing and forced her out of the vehicle along with Officer Beer's assistance. As she was removed from the vehicle, she became entangled in the loose seatbelt. Yeah, that's what I thought. Which was then removed, and Montgomery was forced to the ground despite her attempting to stand up. Montgomery was then hastily handcuffed behind the back. So right here, what they're trying to do in that story, or in that brief explanation, is justify the damage done by taking you to the ground in the manner in which they did. Okay, that right there, specific to, we're going to explain away the slamming and hurting you to the ground, again, without probable cause of a crime being committed, right? There's no justification here that can be made.
Here's the other thing, though, that is a hole you can poke in that. If he weighs 285 and I weigh 100 pounds, I can't even reach the floor of my van where that was stored on my left side of my body. I'm right-handed. I can't reach where that crowbar was with him pinned up against me, and I didn't have it in my hand. So why would he come at me?
Well, it fell out. It definitely was there. I've watched the video enough to watch
it was on the floor.
Yeah, and that's what I'm saying. So it fell onto the ground when they pulled y'all out. It got dragged out or whatever. He's saying
with my feet.
Well, he's saying it hit his head, but he just may be getting confused with the aspect that the seatbelt came and clanged in his head and hit him. The seatbelt came and clanged and hit him in his head. So when they got done fighting and pulling everybody out, he in his mind thought that it was the actual crowbar, but it was actually the seatbelt. See, he's actually explained everything here for you as far as what had happened, because he never said that you had that in your hand. He never said that it was in your hand. All he's ever said is something metal hit my head, right? If we go back and look, what we can see is he never said she picked up her hat in her hand. Okay? Never did he say that. Okay? This is very clear.
I didn't.
Okay, well, that's the point. You didn't hit him. He misinterpreted the seatbelt when he unbuckled it, hitting him in the head somehow, and that apparently in his mind, after wrestling and beers coming over, thinking that it was you with a crowbar in your hand. but it was on the floorboard and it fell out. So of course someone can get confused like that. That's very simple to explain when it really is looked at. That's why it says, I immediately ordered her to step out. I opened the car door before she could lock it and immediately lunged for the space between her and the seats again. In response, she immediately lunged for the space between her seats again. In response, I lunged into the vehicle in an attempt to control her hands and defeat the seatbelt, fearing she may have reaching for a concealed weapon. As I did, I came to lay across her and facing and press against the seatbelt in gear. As I was trying to defeat the seatbelt, I could feel several strikes on my torso area as I
didn't even do that.
Fist. Okay, again, you keep doing the same damn thing.
I'm sorry.
Yup. It's all good.
I don't like being accused of something I didn't do. I'm
It
sorry.
don't matter what this. I mean, it does matter. Everything that matters is what he's saying, but it doesn't matter what if you did it or not. Okay, this is what he is going with. Okay, it works perfect for you. It really does. What I see here, I'm looking at the holes of this dude's story, and what's going to happen is the DA is going to run with this story. But the video don't lay out the story the right way. It can be so utilized because what again he said is, I felt something hitting my torso, okay, torso facing her and pressed my what as I tried to defeat the seatbelt strikes. Montgomery was also writhing and contorting, trying to get away from me as I was trying to get control of her. Then it felt a hard object hit my head. Okay. But he never says he sees it in your hands to hit you. Again, you're clear. This is going to get cleared away. You know that, right? You know this is not, you're not going to be found guilty of this, right? You know you're not going to be guilty of this, right?
Erica, what you want to do is not try to prove that he's lying. You'll do that just by showing that his story doesn't add up. And that's what you want to do. You want to go to the points where like Cameron's saying, you want to go to the holes in the story. Not that he's lying. The holes will show that he's lying. So when he says, that.
Well, wait up. He may not even be lying. He just may be confused on his interpretation of the situation.
Right. So go for the holes in the story. And when he says he got hit on the head, then say, well, did you go to the hospital? Where's the proof that you're injured? You just gotta work those holes in the story.
So he goes on to say, as I seatbelt along with the officer, as I removed, because he never says, he says, I then felt a hard object hit my head in the area on the right eye of the temple area and then heard a metallic clang in my skull consistent with the metal object striking my head. The seatbelt hit your head, bruh. I don't know what else to tell you than that. I didn't have anything in my hand. I lunged away from you because I was scared of you. I wasn't lunging to reach for anything as you were claiming. I was reaching because I was scared of you. Get back! You're like trying to attack me, and as I'm lunging away from you in my car, you're attacking me, and I'm scared because I'm trying to find something to hold on to so you don't pull me out of the vehicle. I'm trying to find the bottom of the seat to hold on to so you don't pull me out of my own vehicle, because I've already told you, as you've stated in the report, that I said you're not going to take my property. So if I'm stating to you that you're not going to take my property and now you are intruding into my property trying to take me, I wanted to hold on to my car so you could not remove me until a sergeant got there, as I requested, which you failed to state in the report. In doing such, you tried to unbuckle my seatbelt. I'm then trying to get you off, and you're saying that as I'm contorting that I'm now punching you because I'm trying to push you off with fists that I can't even open my hands because you're so heavy and on top of me. In doing such, you pull off the seatbelt. The seatbelt comes over and clings you in the head, as you claim, on that same side in which the seatbelt would come to hit you on the head. And then you're pulling me out with homegirl, and then we fall. And then we continue on with this next paragraph here, which says, as I looked back, this says, she became entangled in a loose seatbelt, which was then removed, and Montgomery was forced to the ground despite her attempting to stand up. Montgomery was then hastily handcuffed behind her back. Forced to the ground. Oh yeah, she was forced very badly. As I looked back toward the driver's door, I'd noticed a black metal crowbar laying on the ground just outside of the open door. Great! But what does that mean? That doesn't mean you got hit with it. That's just the first time you noticed it. That means it was on the ground underneath her feet or in the car door in and of itself. You're saying she lunged away from the crowbar, indicating that she did not reach or have it in her possession, nor did you ever see it in her possession, thereby indicating that you have no proof that she hit you with this crowbar, correct? No. Okay.
You would know if you got hit with a crowbar. Just saying.
Thank you.
He didn't get hit with a crowbar. He's walking around and they over here planning out everything in front of the cop car, bruh.
And I think they thought they were far enough out of the view of the camera that they wouldn't be seen. Because if you notice, they're pretty far over to the edge.
I think that whole point is beyond the principle that he accosted her in the first place. She probably had every right to hit him with a crowbar. And that's where we really need to look at this thing. You know, what happened? Why is he in her car? Why is he pulling the door open? That's the first cause.
Right. Well, the only thing he stated was he asked her to get out in relation to Pennsylvania versus Mims. Now, I can sit here and go into Pennsylvania versus Mims and we can look at the elements real quick just so that, you know, we have a good, fresh little understanding here.
I think that's what Erica needs to understand, is he had no right to open her door and accost her in the first place.
None.
I told him that.
Can I interject for a second? I need to just hold space for a second for Erica, because you are right now reliving something that was extremely fucking traumatic for you. Yes. So it's understandable that you're feeling these emotions and that you feel like you need to defend yourself because you absolutely were fucking traumatized. So it is okay to hold this space and be in the space of this trauma that you went through, because that was extremely traumatic. So feel that, breathe through it, feel it for all that it is, because that is going to help you heal through it, and just you're loved, and just feel through it, breathe through it, and just know that you're loved. And that was very like, oh, I'm an empath. Yeah, that was extremely fucking traumatic. Extremely. So yeah, you're a warrior, you know, you are.
And we're all here for you, Erica.
For sure.
Thank you.
And you can just Google treatise on false arrest and false imprisonment, and it states out that any detainment of liberty absent a due process is a false arrest, false imprisonment.
Where do you find that?
No, it's not.
Treatise of false arrest and imprisonment. It's online. Anybody can download it. And it cites court cases and everything. Please. Treatise on false arrest and false imprisonment. Anybody can get it, and it's
that's right. Yeah, I have a
Shepherd.
PDF file of it.
Yeah, it's shepherdized.
Yeah, you get a PDF file of it, so it's free.
Any detainment of liberty absent a due process is a false arrest, false imprisonment.
Armed and dangerous. Reasonable suspicion. Suspect is armed. Reasonable suspicion. Suspect is dangerous. If no suspicion is found. Fourth Amendment violations all day. You see, no blanket privacy violation.
Not only Fourth Amendment violations. That's First Amendment, freedom of assembly. Of course, Fourth Amendment. Fifth Amendment, right not to incriminate yourself. Sixth Amendment, right to an attorney. Ninth and Tenth Amendment violations of rights not delegated.
The aspect that he attacked her right off the bat is the biggest for me, though, bro. Like, if you just stepped out, why did you attack her? Like, what was
That's
the
where I'd
reason for
focus.
the attack? Yeah, that's me too. That's where you get to the aspect of the moment you opened up the door and attacked her is where you violated her rights. Thereby, anything that happened after that in which y'all are claiming is null and void and has to be suppressed. Thereby, just leaving nothing left but the traffic tickets. You see what I'm saying? That's how it's supposed to go. That's how law goes. When you do it right. That's what we're going to attempt to do. So it says, as I look back toward the driver's door, I noticed a black metal pry bar crowbar laying on the ground outside. This object had not been there during my initial contact with Montgomery. Upon review of the video, the crowbar also did not appear on the ground until after Montgomery was out of the vehicle, indicating it did not fall from the area between the door and the driver's seat where I initially opened the door. What do you mean? What are you talking about? What? What did you just say? That don't make no sense. He said, upon review of the video, the crowbar also did not appear on the ground until after Montgomery was out of the vehicle, indicating it did not fall from the... Okay, what do you mean? So now you're putting in your own story and thinking of belief of things that you don't know to be true. You're just coming in blatantly now and putting in your own story by saying, indicating. Do you know for a
that's
fact...
good though.
Yeah, I know it is.
That's good. I mean, if it wasn't there when she came out of the car, how did it get there?
Exactly.
Who put it there?
Your hand?
Right. This led me to believe Montgomery had used that object to strike me. This led me to believe. Okay, leading you to believe and knowing and seeing are two different things. You see how this case is dead on its face, bro? You see how this case is dead on his face, bro? This case is nothing, bro.
Are you sure without a doubt that she had it?
Exactly. Like, are we seriously in this courtroom right now because you've been led to believe that in the scuffle of your illegal actions by thrusting yourself into her vehicle illegally without due cause, without any probable cause, without any warrant, justifies... But yo. We're not finna play with this woman's life. What kind of criminal record history does she have? None? Nothing? Okay.
Nothing.
Nothing. Yeah.
I don't even have a speeding ticket.
This ain't gonna play out. So this led me to believe Montgomery had used that object to strike me in the head and that it had fallen out of the vehicle with her when she was forcefully removed. Sergeant Leone arrived and took control. They're doing this because they slammed you out and they didn't have to. They know they got lawsuits, so now they got to figure out something. Who was then searched and placed into the rear prisoner. As I looked at the driver's seat area, I also noted a large folding saw placed on the left side of the driver's seat between the seat and the door. I also noticed a large pair of channel lock style pliers in the driver floorboard. Oh, well, if you saw... Well, looky there. Look at you giving us more clues on where that damn pry bar would be. So it lead me to assume that if we got large pair of channel lock style pliers... If we've, it would also lead me to believe that if we've also got a pair of large channel lock style pliers on the driver floorboard, it would be safe to assume also that's where the pry bar might be too. Wouldn't you believe so?
Full of weapons.
I love it. Are they weapons or tools? Let me ask you this: if people are rolling around with crowbars, they got rocks in their car, and they've got, bars and, channel locks. What would you assume that might be that they do as a hobby, good sir officer?
God forbid she had a pocket knife in, the door compartment.
All right. Can't have no weapons now to defend yourself as a little old lady, right?
Right.
Can't have no weapons to defend yourself against those baddies out there. So,
Just the act of the weapon in the car makes the Constitution void.
Facts.
You know what? I had a pocket knife that was an inch long on my keychain. They took that too. They took all of those tools that you're talking about. They took all of them.
Yeah, they're your tools. They're your private property.
They also took my grandfather's World War II knife that was buried underneath the seat.
Don't worry.
That's what she's trying to say was on the seat.
Don't worry.
It was buried.
Don't worry. You're gonna get that and lots more money back. Okay? Don't worry. You're gonna get that and lots more money back. Okay, this is constitutional violations. You're in the aspect of attacking like I'm attacking with my civil suit. Okay? That's where your mind frame needs to now be at. I now have the power. You fuckers fucked up.
I know.
I
they're
see
fucked
how
up.
much power you have now behind you. These boys are so dumb. Okay, my initial contact. Upon review of the video, the crowbar also did not appear on the ground until after Montgomery was out of the vehicle, indicating it did not fall. Okay, yeah. This led me to believe, we don't care what it led you to believe, homeboy. Forcibly removed. Sergeant Leon arrived and took control of Montgomery, who was then searched and placed into the rear. As I looked at the driver's seat, I also noted a large folding saw. Yes, we said that. Driver's, yep. And the channel lock style pliers on the floorboard. And on the top, a large knife handle protruding from the pocket on the left side of the passenger seat. Okay, that's great that you've seen all these things, but were any of those grabbed? Were any of those in her hands? Can you show that on your cam? You can say all these things that you want, but that is non-applicable. All of these items, as well as that was after, because you didn't know that till after. You observed those afterwards. You found that out afterwards.
Okay.
All of these items, yeah.
I think you said he put in there which side of his face he was struck.
Yeah, his left side, I think.
Okay, I thought you said right side.
I think it's left.
Okay, all right. If it was his right side, that's in the report, and he was claiming to be inside holding her down. How in the hell would she been able to hit him on the right side of his face when the right side of his face was against her?
I remember him saying left side.
Okay, my mistake then. Sorry.
No, it was his right side. That's what he points to in
I
the
remember
video.
right side too.
It's his right side. But either way, if he's pinned up against me, how am I supposed to pick anything up when he's got one hand? How am I supposed to hit anybody with anything when I'm pinned by a 285-pound man in between my seat and I can't even touch the floorboard?
I think we're
from a
talking about
seated
irrelevant
position.
facts.
I know.
That's not where we want to go with this.
Yeah, you don't want to take the argument towards that because it's gonna just it's blurry, and it's just you'll never be able to win that with certainty. You know, that's not a certainty thing we can argue because there's no proof of it. So it's just
Trying to make a case with that pry bar on the floor, saying that you hit him with it because it was there. And he has no proof that you had it in your hand at any point in time. He just believes that you did. And believing and knowing are two different things.
Right. Reasonable
Bigger
doubt.
than that, he says it wasn't. He didn't even notice it until after she was out of the car.
Right.
It wasn't there when It
Right.
wasn't there when she got out of the car. It was there after she got out of the car.
And he never in his report ever stated anything about she reached for it, she had it in her hand. I noticed she had grabbed the crowbar. I noticed she had
Like
grabbed
this
the knife. So it was never an indication of she had a weapon in her hand, which made me then lunge in. It was never that. A sign. Then it says all of these items, as well as miscellaneous other items and rocks. You put it in there. Thanks, buddy. He's giving you everything in his own incident report. Ranging in size from a tennis ball to a softball were within Montgomery's immediate reach. A sign reading private conveyance, not for hire or reward, not engaged in transportation or commerce, was found inside the vehicle. These statements are consistent with and common with sovereign citizen ideologies. This idiot. Let's look up what the misinterpretation is now of sovereign citizen.
Oh, that would be people who think that laws don't apply to them, Cam.
The sovereign citizen movement, also soft sit movement or soft sits, is a loose group of anti-government activists with their vexatious litigants. Ooh, vexatious litigants now? We're getting big words like that, huh? Tax protesters, financial scammers. Damn, we're financial scammers out here too, bro. And conspiracy theorists. Whoa, damn. Gotta watch out for those conspiracy theories, y'all. Found mainly in English-speaking common law countries. The United States, Canada, Australia, and United Kingdom. Wow. Okay.
Hey, I would also like to note that same evening there was actually a conference going on called Liberty on the Rocks. The same night.
It's crazy. Look at this. The FBI has called sovereign citizens, quote, anti-government extremists who believe that even though they physically reside in this country, they are separate or sovereign from the United States. It's very different than that 1940 joint resolution, right? which states that it's the highest responsibility to have in our self-governing republic. So this is the kind of aspects that we have as far as what we're fighting. We have agencies, not that I'm saying that Kash Patel is going to, run his agency now that he's running it in that kind of aspect, which I don't think he is. I think, the FBI is going to be a lot better than it ever has been in a long time. But I'm just saying, I immediately ordered her out, objects of the car, stuff out. We already went through that. Where are we at? Common law. Sovereign says ideologies and indicia when dealing with motor vehicles. Well, she's not driving a motor vehicle. It can't be termed as a motor vehicle at the time of her using it because she wasn't in operation of commerce. The crowbar, saw, knife, channel locks, and sign were collected as evidence. The license plate was collected for destruction due to it being suspended. Due to being struck in the head with a metal object, Sergeant Leon requested Sedona come in, and Sedona arrived, feeling where I felt the impact and was feeling some minor pain in the general area. At the time, I felt I was fit and able to continue with my shift and refused transport to the hospital due to police short-staffed at the time. Montgomery was also assessed by Sedona Fire due to the use of force. I was unaware if she was injured or not. I experienced a sudden onset of dizziness that almost caused me to fall. Well, guess what, bro? You could have gotten that dizziness from the actual fall and takedown from Erica itself. When you took her down, you could have been boom, boom, and from the fall. Not from the actual incident itself of you stating that you got hit. So you don't know where it's coming from. Now you just throwing in some conjecture on this is possibly what could have happened. Well, my freedom is not going to be determined on you not interpreting or understanding where your medical issues are coming from. You was not hurt or hit hard enough from me in relation, nor did I hit you. The crowbar and channel locks were right underneath my seat where they had always been this whole time because of all the rocks that I do and utilize and make jewelry from, or whatever I do is my hobby. Like, bro, you're
and I do.
You're
those earrings that he knocked out of my ear, I made.
You're gonna be good on this. I think you really are. I don't know what's going on with your attorneys. I really think once we, I'm gonna let somebody else talk for a second. I gotta go pee.
The injuries that he sustained due to his unwarranted attack on you is not probable cause for him to make up some story that you hit him with a crowbar.
Mm-hmm.
It's all hearsay evidence.
Guys, but all the stuff in the car, it was so scary. The pliers have teeth on them, guys.
Yeah, all my books.
She can't have a Snickers because he might have got chocolate on his fingers. You know what I'm saying? That's
I
scary
like
shit,
Steve's
bro.
point that in the report
Yeah, he
he
didn't have
says
his
after
gloves on.
viewing in the report, Steve caught this. He says after viewing the video, he wrote the report while he was looking at the video.
It's because he violated you and assaulted you that he's trying to cover his ass. Like, I just got assaulted, and then they're trying to cover. They tried to do a bunch of bullshit. They're not even prosecuting because on review. So it's like I'm moving forward with that, but it's because they had to cover their ass. Like, why'd you tase him 2 times? I was scared. It's like, well, that's bullshit. It's
Get a
total
new
bullshit.
job.
What we ought to be doing is counterclaims, because when we put in a counterclaim of his assault and battery on you, that has to be heard before they can hear his case.
Yes.
Well, let's do that then.
How
do I do that?
They claim in my situation that when they busted my windows, because I was sitting in my car, that the one cop got a jammed finger, and the other 2 got cuts from broken glass.
And that's your fault? Please.
Right. See, right. So, and my question would be, well, who's the ones that broke the fucking windows? Right? Did I break the windows and was sitting in my car? Because I clearly, if you watch the video, I was clearly wanting my windows destroyed for sitting in my car doing nothing to no one.
But that's
Right.
a defense. Do it in a form of a counterclaim. claiming damages for breaking the window. And
Oh, dude, in their report, it says that there's no damage to my car, which they're gonna try to sell Monday morning at 8:30.
Well,
Dude, I spent
That's pretty cool.
5 months in Porter County Jail in Indiana over a public intoxication, disorderly conduct, resisting arrest, and battery on an officer. They said I bit them. I beat that part, but I spent 5 months in there. I just started learning all this stuff. Like right after I got out of jail, I was like, "There's something ain't right." I had a PD. I just had to do what I had to do to get out. I didn't know any of this. How any of this worked until I don't know, maybe like 2 months ago. And this happened a year ago. And I've just been trying to. I know that I can bring it back up. I believe I did get the battery on the officer dropped, so I do know that I'm able to sue them because I didn't fucking fight them. And the whole thing, because I wrote something on here about how we were talking about how these cops are always assuming shit, dude. In there, they said that when they were trying to put me in their car when I was on my property and they get me for a public intoxication, don't make any sense.
You sick bastard.
Dude, they've done this.
You're on your property. What the hell's wrong with you?
Dude, they've done this more than
your
once. More than fucking once. I'm actually fighting Porter County right now on this, because it's still going. I got in a continuous and everything, but
so they have the burden of proof to prove their initial contact. If they can't prove that, everything after that is dismissed.
Yeah, because I mean, like, they just came up to me. They're like, I've been arrested quite a lot, especially since I started learning all of this. I didn't learn enough before. I was like, oh, I'm gonna just go do what I learned and hope it works out, and it definitely did. So now I've got a whole lot of court cases, but it's all bullshit. I can beat every single one of them from the knowledge
Unless you're
that I've
Anthony.
learned. But I don't know how to really go about doing it, and that's my problem. That's my biggest problem. I've been since DCS kidnapped my son from his mother. I was not informed about it. I've been fighting that for like maybe 20 months.
Eddie Craig, man.
And
that's who I can
and
point you to. Eddie Craig.
Eddie Craig. All right,
Yeah.
appreciate you on that. But it hasn't been 2 years yet. With this case, and then I have the recording. I believe I just downloaded it onto my drive. I don't know how to make it to where people can watch it. But it has not been 2 years yet. And the judge said on the record and everything that it's been 2 years since this has happened, and I'm trying to I don't want it to be too late on this. I really need some help. If somebody could please
Listen,
assist
excuse
me.
me. It can't be too late. Did you watch that video that Cam put out with Carl? Was it Carl Miller? He
Carl
stated-
Miller, I watched it.
Okay,
Carl
so
Miller was
listen.
like one of the very first videos that I watched.
Right.
When I
So
started learning.
I just wanted to interject real quick because this thing of statutes of limitations and this bullshit that we can never go back after a certain amount of time to correct something that was fucking wrong is incorrect 100%. And even in equity, you can go back and correct whatever is on. So just please, just for everybody, so you guys have like reassurance that nobody can tell you can't go back to correct something that was done wrong against you, and because you were ignorant, because we're all ignorant at some point, and that is not something that's going to be held against us. So just remember
Yeah,
that.
but
Don't lose faith on
one of the
that.
maxims of law is, ignorance of law is no excuse.
No, that's not a maxim.
Yeah,
That's that's not a
there's
maxim.
no statute of limitations on fraud.
Yes, and that's
Okay, good.
one way to say it. But basically, at the end of the day, nobody can
Regardless,
prevent you at any
so
time.
much.
Yeah, don't lose faith.
Been
That's why
almost
I
2
said that.
years, dude.
No,
Almost
no,
2
no,
years.
no.
I ain't been able to see. I barely got to see them. They went from
Because you're
18 hours.
traumatized. I'm going through it. That's why I'm telling you. My daughter was taken at gunpoint, okay? August. August. Yes, I'm fucking talking about they had like an AK-47, a big ass,
What
I don't
the
know,
hell?
handgun. Like they came because I told the judge I will not be bringing my daughter back to a situation that I need investigated. And her father would not speak to me. He would not talk to me. To me, it's like if I come to you and tell you that something is happening to our daughter, and then you want to play games and not even address that something's happening to our daughter. I feel like a man and a father would be like, who the fuck is trying to mess with our daughter and work with me, And he didn't do that. All he cared about was getting her back from me. And I told her, well, our daughter came to me and shared this. But anyways, long story short, so I told him that I was going to keep her just a little longer to administer some medications that when I took her to the ER, the doctor gave to her so she could heal, because there's actual physical evidence of stuff going on with my 7-year-old. And so what happened was I told the judge, like, I have suspicions of either there's neglect or something sexual happening to my daughter. And I said, and I need help. I need to address these facts here. And so the judge said, no, you just need to return her. And I said, I'm fine with that, but I need to know what's going on with her. So nobody would help me. And I basically told the judge, no, I would not be returning her to an environment that in my heart, I felt that was wrong and something was happening. And nobody was trying to talk about it. So she said, okay, well, I'll send this to the DA. So I said, okay, that's fine. Because to me, I was like, well, if they send it to the DA has to give me notice that they're opening up a case and that they're going to attempt to retrieve my daughter, which I would have never allowed. I would have taken my daughter and just said, you know what? Taken her to her father, because I did not want my daughter or my son to go through that. So what they did was they were like watching me the night before, because I was actually in the process of moving. They sent 8 men, okay, and a few women. The men were armed with weapons. They came at 8:15 in the morning. The day before, the judge who was presiding over our hearing signed her own warrant, which you're not supposed to do. When you get a warrant signed, it's supposed to be signed by somebody who is not involved in the case, because they're supposed to, quote unquote, be unbiased. So the judge quickly and hurriedly signed it was, I don't know what they call it, but it was not a correct affidavit. It was done incorrectly. And then the next morning, I think they had it like the evening before the judge signed. The next morning they came and busted my door down, put black tape over my door camera to cover the fact that they were intending to cause harm to me. They were expecting me to fight back. And everything in me had to hold myself down, because they would have shot me in front of my 4-year-old and my 7-year-old daughter. So they busted through my door and and they were screaming at me. And I literally was standing there looking at them like, you guys are animals. Please lower your weapons. My daughter is literally right here, because we were in our bedroom. Like, we were just sleeping over because I didn't have enough time to move the rest of my stuff to our storage so we could move to our other apartment. So they busted in and there was only a mattress in that room. And that was my last day there at that apartment, which was so coincidence. So, and the guy was like, lower your hands or put your hands up and all. And I said, please stop yelling. I was literally speaking to them like I'm speaking to you now. I was like, I don't understand why you have guns, but what I'm trying to tell you is, okay, that they're going to try to intimidate you and scare you. And this is what the trauma is. They want us to fear for our lives so that we don't go back for what they believe is their property, and that is our children. So it is not the end. It is not the end for you. You keep fighting. You have to keep looking for that information, but just remember.
I've noticed.
Yeah.
Well said.
That,
well said.
I had a public defender.
Hey, Mandy.
They kept issuing me public defenders. Now that it's a termination of parental rights, I put it in a motion saying that I didn't specify the reason why, because I didn't I wasn't doing enough research to find out, that it's ineffective counsel. So I didn't put that in there, right? And I ended up going to jail the day before the day of court. They arrested me. I was walking home from the bar, and it was just a bunch of dumb shit. I was asserting who I was and everything, or trying to, and that case, I've already got the discovery and everything. I'm at the library now working on doing. I'm trying to do a notice of liability for Porter County, Lake County. I don't know if I have to do the cities or I can just do the county.
All of them.
Them all, bro.
All
Yeah,
of them.
them all.
Okay. Thank you for that. Fuck, 'cause yeah, I've been struggling with that. And then, their insurance, their surety bond. When I was at court, the judge said that that DCS didn't have surety bonds. So I've been trying to do everything I can to find out how I'm gonna hold them liable. I've already been working on that. Dude, Chat GPT is fucking awesome, dude. Thank you for introducing me to that, dude. Thank you.
They're going to lie to you. It doesn't matter who you're talking to. They are
Dude,
going
had me.
every single.
I've been bringing my smartwatch into court with the juvenile court, right? Last month, I think it was last month, maybe 2 months ago. I don't remember. But
court
they caught me. The bailiff came up to me. He was like, "Are you recording?" I just ignored him. I'm not gonna fucking answer you.
Hey,
fucked up.
Hey.
And then,
hey, bro.
I knew that. Hang on. But I knew that, so.
Hey, bro.
I knew that they were probably gonna take it, so I bought one of these spy cameras and or pens. So I've got that, and that's what I just downloaded on my drive. So.
Nice. Hey, Papa, I'm gonna continue with Erica. Is that okay with you?
Yes. I apologize.
No, you're cool. You're cool. I didn't want to interrupt you. I just want to let you go for a little bit. So.
All right.
All right, cool. All right. This is, I think, the second incident report for her situation. Supplement. I heard dispatch tell Officer Santos over the radio that the vehicle he was out with, traffic stop, blah, had suspended plates. I was on an area check at the public library, meaning that she was just sitting in the parking lot, and began to roll towards the traffic stop. Officer Santos, okay, here we go. As I pulled into the parking lot, Officer Santos was at the driver's window of a gray Honda Odyssey passenger van. Just as I placed my vehicle in park, Officer Santos opened up the door of the car, reached inside towards the driver, and there was a push, pull, struggle. Officer Santos was bent over at the waist inside the vehicle. I quickly reached over and activated my GTAC camera system from the monitor, opened the door to my patrol vehicle, and ran to assist Officer Santos. As I approached the vehicle, Officer Santos was pulling the driver from the front seat by her right arm. What he could not see was that she was wrapped. She wrapped her left arm in the seatbelt and was holding onto it. Oh, so now we know that both hands are free. One arm is held, one arm is holding onto the seatbelt. Great. Meaning no object was in the hand. Great. I called out, "Seatbelt, seatbelt," and began to unravel her left arm in order to take her to the ground. Once on her belly, we positioned ourselves to detain her and keep her from moving. Officer Santos held both of her wrists together at the small of her back. As I placed handcuffs on her, Officer Santos then pointed to a large crowbar on the ground and said to me that she hit him with that. Pointing to his right temple area, there was a red mark on his upper cheek and eye area. Well, too bad that it wasn't a crowbar that hit you. That crowbar was in the floor. It was never in my hand. It was sitting right next to the channel locks. It's what I use to break open the rocks when I'm doing and making jewelry. I crunch them down. I break them when they're in the bigger status. It was on the ground. I had the seatbelt. Your officer yelled for the seatbelt. The seatbelt metal part came and hit your face in the struggle when you illegally pulled me out of the vehicle, thereby making you think as you fell, we all fell down so hard for some unjustified reason that you had to pull me out so violently, rather than just opening up the door and then again reiterating, please step out of the vehicle, rather than violently pulling me out as though I had committed some sort of crime. Then we go on to see Sergeant Leone arrived on the scene to assist discovering what had just occurred. Sergeant Leone called for Sedona. Injury, Sergeant Leone had stood the suspect up at the time. I was searched for weapons and escorted the prisoner. I took photographs. It was then realized that my BWC, body-worn camera, did not activate. Yeah, okay. Well, it was illegal. It was illegal for you to even open up the car door in the first place. For what reasoning? What was the reasoning? Let's see what else we got as far as documents. So that's pretty much it on the explanation. It seems like it's a little bit more weak. A lot more weak than we initially thought. And now that they've given their story, it seems as though it's very clear on the holes and the things that we have to address and have the public defender address. I don't think it's as complicated as you may have thought, Erica, as traumatic as it is for you. I think for us, it shouldn't be that complicated for a public defender to easily poke holes. And maybe that's some of the things that they were stating was, we're going to go about it this way because, but they just didn't clarify it, and in not clarifying it, you want to have a good attorney. So by them not communicating explicitly with you on what they think you should do or what you believe that they should do, and have good communication there, of course that broken communication causes conflict on being able to get a resolution in which you want. And if that's there, then of course you need to move around and find another, and they have to assign you one. And you can keep going until you get a good one. You don't have to be burdened with anyone that's not doing as you requested, especially if it's in the proper manner for your constitutional rights being violated. Not just your constitutional rights, but several rights beyond the Constitution, which are your natural rights. Your natural rights just to be free, to live in happiness. You wasn't even operating in commerce, and they can't prove that you were operating in commerce. So the stop in and of itself is unjustified. Yes, did you run the red light? Yes, you did. Are those things in which they have eligibility to pull you over? Yes, they certainly do. According to case law, and that's definitely when, stoplights, speed, any kind of things that could cause harm, those are definitely things you can be stopped for. Anything beyond that is null and void. But the justification was a real stop. There's no doubt about it. But was the justification of you rolling up your window, as they has clearly stated, justify him opening up the door as though he can now attack you like that? No, not at all. And so everything from that point forward of him illegally entering into your vehicle is just, it's out of bounds. Oh, wow. Troy, you got the 2-camera system set up. That's dope. Ooh, I'm all in Troy's house. What? That's crazy. We vibing. Oh boy, got 2 cameras. So what I want y'all to know just real quick is I guess I'll show y'all one last thing for anybody new that's in here or just doesn't know exactly what we do. We just went over Erica's situation. And what we're going to do is we're going to do something very similar to, let's say something like this, right? You see all these documents in here, y'all? Let's see. You see all these documents in here? Okay. Declaration of probable cause, evidence, transcript of Fellner's body cam, motion to dismiss, Louis' motion to dismiss, amended motion to dismiss, Louis' motion for relief, motion for disqualification, script if denied. Okay. If judge denies, arguments based on the motion hearing. So let's say we come in here. It's just where we gonna put this. I got Louis' folder in here. Yeah, it's just throw it in here. If it's a copy, whatever. Open this bad boy up. So this is a hypothetical courtroom exchange script, getting us into the aspect of what Luis would say. May it please the court, Luis, appearing in propria persona, I'm here to support my motion to dismiss on all charges against me with prejudice. This motion is grounded in constitutional mandates, Washington statutory law, and controlling precedents. The state's conduct in this manner, which includes an unlawful threat of arrest, absent reasonable suspicion or probable cause, of course, this misapplication of forgery statutes and the prejudicial labeling, as far as the Constitution is concerned, sovereign citizens, their biased outlook on who I am and who I know that I am, and of course the prosecutorial overreach, which is utilizing this forgery charge to be applicable to me, requires immediate judicial intervention to preserve my due process and uphold the rule of law. And I want to speak on that here today. The judge, let's say whatever he says, but let's say the judge says, I understand you have concerns, but let's be brief. The state is entitled to pursue charges if it believes a violation occurred, which it's already done so, in which we spoke of in our last omnibus hearing. Then you would come back and say, Your Honor, I must respectfully object to any suggestion that the state can simply pursue charges at will without meeting the constitutional and statutory criteria. Now, I understand that you asked me to go ahead and file this memorandum as well as a notice to dismiss based on the unconstitutionality of the statute as it's applied. And so what I wanted to do is, under Terry versus Ohio, U.S. 1 and Article 1, Section 1 of our state constitution, of course, a forced identification stop or threat of arrest mandates reasonable suspicion or probable cause. And no justification such existed here, as the body cam footage shows. Now, I am aware that you probably haven't viewed that, and you're not going to until we maybe get to an evidentiary hearing or anything like that. But the officer threatened arrest solely for refusal to identify, which is constitutionally indefensible, okay? Then let's say the judge was to respond again, isn't refusing identification-based behavior, Mr. Ochoa? And then defendant would say, so what we do is we build lots of things. So this right here is just like the aspect of what we could build for arguments and prepare. And this is just one angle. We make several. An outline for another oral argument at the motion hearing. And this is a total different outlook now on hearings. These are just hearings now, suggested outline. So this would be like, if you've got things that you've practiced on with the script, of course you're not going to read verbatim, but if you have an outline and you've read the script enough times, you can have an outline for the hearing to know the introduction and what you need to state, something small that you've highlighted, you can mark off and cross out and go through everything through the actual hearing in and of itself. So that way, again, we are prepared for what we're going into that hearing itself, fully prepared. Now, Luis didn't follow this on the last one. He went in with just a crazy, he had a real true moment to go in there and shine on this status hearing by filing his notice and demand as well as his memorandum with all of the points and authority in which the judge had just previously requested the week prior. But he didn't. He went in, and me personally, I'm gonna keep it real with everybody, and I said the same to him. To me, he made himself look very bad on this last hearing. And the reason is because he went in argumentative, he went in unprepared, he went in stating the complete wrong things, being misspoken in relation to a mistrial. He has gone out and spoken to other people, and he's just putting things on the record he's wasting time. And that's what I had to tell him. And it took me a good hour and a half to run him through this whole process over here, which I just had to share again. I had to redo everything again and share it all over to him so that he fully understood, which is all of the new stuff, which is your motion for interlocutory appeal, your motion for an evidentiary hearing, the disqualification of things that are still going bad in relation to the judge not ruling in your favor, a motion for more definite statements, right? Because we haven't gotten real true statements on how these statutes apply and what the theory is from the state in and of itself. Since we haven't been able to get that because they haven't properly rebutted Luis's motion, even though it was denied, we still need to get a good rebuttal. We need to understand, let's go through this for a second. And again, these are documents that are part of the process, y'all. These are documents that are part of the process. You see what I'm saying? So if it's part of the process, we need to comprehend and know these part of the processes and angles in which you're going to get and make the state. Like I said, you ain't got to come in with this big ass, like a ping pong table. You ain't got to come in and slam that bad boy down, bro. All you got to do is bink that bad boy back. Hit him with something in the process. Hit him with a bink. Let all liability and hit so many. Now you've hitting them with so many binks, they actually having to work. And guess how many cases they actually have to work on, bro? Beyond just yours. You see what I'm saying? These lawyers don't hit them with this type of stuff. So when you hitting them hard like this and making them work because they're the ones bringing charges against you, quit trying to fucking defend yourself. Quit trying to defend yourself so much. and make them work. They have to prove without a reasonable doubt. They've got to show their theory in which you have an honest and true eligibility to defend yourself based on understanding. Because if they don't give their full interpretation and understanding as far as what they are doing against you, then how can you properly defend yourself? And if you can't properly defend yourself by knowing the theory in which they're bringing forth against you because they haven't put it down on paper, they've charged you, but the statements aren't definite enough to know the exact theory in which they're going with, that there breaks due process. Hello, that's a right.
Bro,
we have to get to the understanding of the foundation of it all. Okay? Hit them hard, put the liability back on their ass, right? So let me get back over to desktop share. So this again is just another document, defendant's motion for a more definite statement. I need this state to work. This is real quick. Comes now. Appearing in pro pos and hereby request that the Honorable Court order the plaintiff, the state, to provide a more definite statement of the charges pursuant to CRR 2.4e, applicable constitutional norms, and the inherent authority of this court. The charging documents and the state's subsequent filings remain fatally vague as to crucial elements and factual underpinnings, thus prejudicing the defendant's rights to notice of the nature and cause of the accusation. Lewis went in there and said, affidavit. I need to know the nature and cause affidavit. I need the 3 elements. You don't just go in there, bro, with your affidavit. He asked, what motions have you filed? This would be the motion. If you want to attach the affidavit with it, great. But at least give a formal understanding to the court to listen to you properly, Papa. Okay?
Okay.
You made a copy of that?
We're hearing you, Cameron.
Despite the state's sweeping allegations. Yeah, y'all can have this. Hold on. It's in the chat right now. I just sent it. Okay.
Thank you, brother.
You're welcome. Despite the state's sweeping allegations of forgery and failure to transfer title, among other nebulous references, the information fails to articulate, number 1, the precise conduct allegedly constituting a criminal written instrument and intent to defraud. Those both elements have to be met. 2, how or why the state presumes a private plate is an official form. How? I need you to show me on paper and respond to my motion to dismiss on how these elements are. I need these definite statements. It is a requirement under CRR 2.4e, under my rules, or local rules. 3, the factual basis for concluding the alleged offenses occurred within lawful jurisdiction or statutory definitions. Okay? That's why we're now getting outside of the statutory aspect. Like the judge said, hey man, we took this as a statutory application, this motion here. Well, if you want to talk about the constitutional, we got to get over there. You got to hit me with a notice and demand. Okay? This glaring lack of detail. I don't know how I got on the edit with this, but that's crazy. This must be some new thing. I don't know. Oh, that's weird. Oh, this is for my Zoom? I get to use it for Zoom? Oh, okay. This glaring detail. All right. CRR, due process. Oh, it's very sensitive there, guys. Okay. Oh, it won't let me scroll. Gotta get out of it. Oh, it just stays on the screen. That's horrible. How do you make that go away? Oh no, trash it. Oh, clear all. Okay. The factual and procedural backdrop. We got all the facts that came with it. We need a more definite statement in our legal standard. The criminal rule states that if a charging document does not sufficiently inform the defendant of the charge against him or her, the court may direct the filing of a bill of particulars. I need a bill of particulars, homeboy. That's what I need. Guess what? You don't get the bill of particulars until you invoke and request it through a motion for a more definite statement. You see how we starting to understand the process is what's key to making them. There's so many requirements that they have to do that we don't know about that they get away with not doing because we don't invoke those requirements. It's like so wild, bro. So now what this deputy has to do is he now has to give us a bill of particulars. That's what we need. You gonna produce it, homeboy? You know how much other shit you're gonna have to produce here real soon? Like Luis has to get into the mindset that I have to subpoena people. I have to request an investigator. I have to file for my evidentiary hearing. I got to file for my motion for a more definite statement because I need a bill of particulars. You see, this is just this right here. Like what? Okay, let's make them work. No wonder why they drop cases sometimes against people out of just the blue. Shit, we're hitting with a whole bunch of paperwork. You want to charge me? You're going to have to work to take my rights and liberty and freedom away. I guarantee it. Because my rights and liberty are set at a very high bar. Constitutional notice requirements. Bringing it in. To satisfy due process, the information must allege facts supporting every essential element of the offense. There's what you wanted to be included, Luis. You wanted to bring this up, right? It's already included in stuff I developed for you. You just ain't looking and reading. You're somewhere else off in Lulu land listening to somebody else thinking that you just gonna dead stop them with what they're bringing forth in what they, it's a process. That's what I'm telling you. These people don't tell the process, bro. That's always been my problem, is that these people don't tell the process. They talk about it, but they don't say what motions are supposed to go. How are you supposed to include it? What case law in your district or your area? Just like these ones here in Washington, okay? We're not reaching to other districts. We're writing our own, okay? The second one is, there must be enough particularity to enable the defendant to mount a meaningful defense and avert double jeopardy. Thank you. You need to give me enough information that I must understand your theory, again, like I said earlier, to mount a meaningful defense. If you're not giving me everything I need to mount a meaningful defense, then my due process, it's all getting violated here. Where the state's language is vague or conclusory, it definitely is vague and it's very conclusory. Because all y'all are doing out here is saying that somehow my own private property notice plate on my private property is somehow now articulated as being me coming out with intent to defraud the state, as though it's an official paper document by definition of written instrument within the own definitions and terms in the statute of forgery in and of itself. Okay? The risk of that court or jury to convict on an unalleged factual theory, or that the defendant remains ignorant of the premise acts forming the basis of the charge, which is a violation of fundamental fairness. Then we come into the conclusory lack. There's so much here. So that's I could go into it, but that's just one element. They haven't even given us no discovery yet. Then the motion to suppress is coming out. We can suppress a lot right now, but we're not even going to go through that yet because we ain't received discovery. Then we got our proposed order. Then we got what was requested, like I said, what was requested from the judge, which he didn't do on this last one, which was ready for him to do. He just didn't do it. I don't know why Papa Bear didn't do it. But this is the notice and demand to dismiss for unconstitutional statute as applied. This is just the notice and demand. You'll see we go into all the details on why. Okay? Very nicely structured, ready to go, complete. All the way complete. Nothing that you need to do whatsoever. It's complete. It's ready. And then also the memorandum. Okay? Now this memorandum, it's okay. Big burp, big burper. Okay, all right. Let's mute up for burps.
Good push.
Memorandum of points and authorities in support of defendant's motion to dismiss. So this is the memorandum of all of the points and authorities in support of the motion, or should I say notice to dismiss, it should be, for unconstitutional statute as applied. And this is 11 pages, okay? All sound, with all footnotes, with all your explanations on each footnote to allow you what we're talking about. Quick little overview, because you're going to need to go through these as we develop these, and you're going to have to come through and say, you know what, I need to search on Google and read about that. And you're going to go read about it. And you're going to find out where that this footnote was in your document, so you figure out how it applies to you. You're going to study, you're going to quickly read and go over the aspects of the case and figure out how it applies to you. Now, with everything that I do now, I've gotten so far along to be able to figure out how to do it, that every aspect, you see how it says RCW? Well, that's because we're in Washington, so this case pertains to Washington. And every aspect of documents and things that we are creating, fine-tuning. This doesn't just come out like I requested and it just gives it to me. It's a lot of fine-tuning we got to do to get it to where it's at. But everything is directly to your state or circuit court, okay? We're no more reaching. Because even though we know other aspects, I'll see you later, Miguel. Have a good one, Papa. even though we know that we can use other circuit courts to other circuits or districts to utilize and support, they don't have to abide by that in our local district. So why not just use our local district and support that, because we'll be able to find it. I guarantee you something similar is going to match. Okay. But I just wanted to really touch base and let everybody know, if this is your first time here or not, y'all know that this is what I'm doing on the back end with everybody, y'all. This is not just a one person Luis type thing. So like going through what we just went through with Erica, that's what's about to happen with Erica. We're about to get to development. The only difference between Luis and Erica is everything for Luis is set up on Profile Persona. For Erica, we're going to set up everything as allowing the lawyer to come in there and edit and finish up everything else as he sees fit. Because we now have a really great outlook on what we can attack on the stories from the incident reports. There was no aspect of Erica hit me with a crowbar. There was no Erica had in her hand and swung. There was no indication whatsoever in their story. It was, I believe. The actual quote was verbatim, I believe. Well, there's definitely enough doubt that we can be able to cast to stop this dead in its tracks. If we have to, we can hit with an injunction. I think this injunction would go really, really good. Me personally, I think it would, just due to the fact that he's gonna have to sign a sworn affidavit stating that she, we put in the injunction, under this injunction, they come forth that Santos, under sworn affidavit, saw me, Erica Montgomery, with a crowbar in my hand and swing and hit said Santos in the temple, right? And it was not off mere belief. Every aspect of every day of every moment, I am having to relive the tragic, traumatic experience and hit on with that TRO on the deeper aspects. Like I've told y'all, self-governed bruh, when it comes to you, you're gonna know. If you haven't ordered self-governed bruh yet, you're gonna see how the deeper aspects apply. I'm not bringing it out yet just because I haven't completely taken this Operation Wisedome completely private, like subscriber based, 100%. But when y'all understand, once this gets more on just subscriber based completely private, when y'all understand, I want to get into self-governed bruh and like openly read that and talk to y'all about each chapter. Like each chapter is like a 3-hour session in itself of a course. Like that's how deep this book is. And I just want y'all to know, like, it is amazing what we all are about to come into as far as knowing.
Put that link in there too.
What?
So we can buy it. Yeah.
Where's that bad boy at?
Appreciate you, brother.
For sure.
I just wanted to say too, man. I think there's a bigger picture here that everybody needs to kind of wrap their head around. It's the fact that they do not have standing to even bring charges. Period. Period. I mean, the fact. Okay, so I mean, just think about it. Like, someone says something. Oh, okay. So what? That's all people do all day is fucking talk. So if you look through all my stuff, it's on, so anybody can paw through it if you want on the Discord there. Every single statement that's supposedly sworn under the penalty of perjury is not sworn under the penalty of perjury. Or it's signed, but it's signed by someone else. So the layers to this are so disgusting. But none of that shit even matters. I mean, because the reality is they do not have standing to bring suits. Full stop. Full stop. I mean, by any metric of anything.
And that's why people don't show up. It's a fact. That's why I have a lot of my people don't show up. They don't show up at all, bro. They file their injunctions and they don't show up. They're like, you have no jurisdiction over me. your attempts to continuously pull me into your jurisdiction without, and what they'll do is they'll send you letters in the mail saying you need to show up. We're going to put a warrant out for your arrest, all that. Well, if you accept that, don't send it back or don't send back a rebuttal, they're accepting that you accept that, right? It's kind of like, it's almost the same exact thing as these debt collectors. It's almost the same exact thing, except in our minds, we think that they have more power because we've allowed that to be applicable to us by just indoctrination. So if we can remove that overlay of seeing them any more differently than the debt collector, right? Which they do have, they will go outside of their jurisdiction, especially after they're put on notice. They do it all the time. But I'm telling you, you have so much more suit when you're at least putting them on notice, right? If we're at least putting them on notice, if we're doing the proper steps, at least there'll always be remedy, right? Because why? There's irreparable harm. And that's why I say self-governing, bro, is so important, because that aspect, even of itself, like today I went on, and I saw someone live on YouTube, very smart guy, just real quickly, and he was live before we came on. And what is he talking about? He's talking about his focus on this live stream was bill of particulars. And I'm just like, yeah, I could go into that at some point, but I think it's just going to be better that I wait to get into bill of particulars when we actually go through the chapters of self-governing, bruh, as a series, because that's the plan. I just need to take this off the free aspect, right? This is still free as Operation Wisedome, so I need to lock it down a little bit more, because people will come in and take that and run with it somewhere else, right? And then everything that I've created is just somewhere else and being profited somewhere else, right? So I definitely want to at least try to get this as the home base for everything that we're creating, because nobody's talking about it out there at all. They're not talking about the injunctions. Yet I'm having people come to me that's gone through 2 lawyers saying, I need help because an injunction's been placed against me. You see what I'm saying? They're like, help. These lawyers don't know what to do. But yeah, okay, let's get to it, Papa. So that's wild to me. Go ahead, Erica.
The other thing that I would like to point out as a false thing in the police report is the 4th officer listed to respond is the deputy chief of police that was just recently fired.
Oh, wow. Well, you should.
There weren't 4 cops there.
Okay, well, you subpoena him, and then that's a mistake on the record. So that's a good mistake that we can utilize and play some action on. And then we should try and subpoena him. I would get that dude on your side, even if he was fired, because he may utilize you as a ploy to get against them. You see what I'm saying? He got fired. He's pissed. He's emotional. Utilize him. Pull him on your side. Subpoena him. Say, hey, what's up? Let's talk. We'll go against them already. You see how I be thinking? I be thinking in who can I get on my side?
Should I call his lawyer?
Man, I would call him. I would find out what his email is, and I'd say, man, that's awful what they did to you.
I'm pretty sure I
Cameron.
have his email. I think I have his email.
Man, I would reach out and I'd say, it's very terrible what happened to
Well,
you.
actually,
I
his
have a
email would
case.
be the police one.
And I'd be like, yeah, I probably would. That's gone. And I'd be
It's
like,
very
look,
possible that because he was there, that it's all political, that he got fired and he's still on.
He wasn't there, though.
He wasn't there.
Wasn't
Oh, he
there. They
wasn't
said.
there.
Yes.
No.
So that's what I'm saying. She could use him to have him use her as a ploy to go against them in conjunction with her, for them using him on their paperwork to, you see what I'm saying? And now it's like, you see what I'm saying? I think hey, can I have you on my team too? Let's
Yeah, to go against the false statements.
Yeah.
The other thing I wanted to throw
I
out
should
too is,
contact his lawyer.
Well, wait a minute. You just said something that's key. You said false statements, and we're about to end this because we're over 3 hours. But you said false statements. What false statements were made?
He
Other
made a lot
than
of
what,
false
Erica?
statements.
Wait, no. Erica, stop. No, not
Yeah,
Erica.
there's
Hear
a
from
bunch of
everybody
holes
else.
in his story.
Okay, but what false statements were made?
The assault of how he got hit with a crowbar.
Wait.
That's
He
with
never.
the
Wait.
evidence, though.
He never said he got hit with a crowbar.
Okay.
Nobody ever
He
said.
got me.
Nobody ever
Yeah,
said.
nobody did.
I was hit with a crowbar.
Yeah. You got me like Columbo, man. Good job.
You got to think about it. So what false statements were said? Can anybody that went through this Erica situation with me tell me one false statement that was made? What false statement?
I just got stumped.
They said she was driving.
That she was driving.
That she had a motor vehicle.
Yep.
That's a false statement. You're damn right it is.
A couple of them just like that too.
There's a couple of them just like that. But what is the substance of the incident report? The substance of the incident report is, I believe. Not that Erica did. Not that Erica grabbed. Not that Erica had in her hand. Not that I observed Erica reach for.
Speculation.
Okay?
Straight up.
Okay? And even in such, what was the reasoning and justification for opening the door and assaulting Erica? What was
He
the
was
reason?
scared of the license plate. He was scared.
For safety.
He had to pull out Pennsylvania versus Mims because he was looking at that license plate and thought, cool.
So you say officer safety, Steve. Steve, let me ask you, since you're the cop, Steve, so you say officer safety. What things led you to believe that Erica was dangerous in any form or fashion whatsoever?
I observed stuff in her vehicle.
Okay, what things did you observe?
Things that could hurt me.
Okay, again, if you don't mind, this is someone's life at hand here and at stake. Let's get away from the things and let's get a little bit more specific if we may. Is that all right with you?
Sure.
Okay, what things specifically did you notice that gave indication of threat or danger or harm within her motor vehicle, as you claim, which we'll speak of later?
She had something in between her seats. There was
Something. Okay. Stuff. Okay. Again, we need to get a little bit more definite here. Okay. What things, stuff did you observe that showed immediate threat of harm or danger?
A piece of cloth.
Okay, so clearly we're having complications on you being able to understand or articulate something. So let's just go back to your incident report, Mr. Santos, Steve Santos. So you stated that she lunged forward a couple times and you observed her grabbing some things. What items did you observe her grabbing?
I didn't have time.
Okay, so you didn't have time to observe. You just noticed there was some movement going about?
Well, there was stuff laying on the ground.
Okay, were you able to observe what was laying on the ground?
After I observed the video.
Okay, what video are you indicating?
From the incident.
Okay, so your body cam footage after someone went into the vehicle illegally to search it?
It wasn't illegal because I was in fear of my life.
And what items were in the vehicle specifically that led you to believe that you were in immediate harm or danger?
Well, the video shows it laying on the ground. I put that in my report.
This will get beat up all day. We kill that, bro. And cops are not. Once we articulate a line, because like this is how it be. If you're going in to actually do cross examination for yourself, what we would have on a document is we'd have a top part, and you'd have different aspects of different points that we're going to bring up, so on different pages, and you're going to have 3 different rows of lines of questioning. So that way, if you start going down this line and things ain't going the way you want and he doesn't answer right, you can switch over to the other 2 and then play off the others to where they all tie into one subject at the very top. And it's all based on yes and no answers from him and how he answers. Like, that's how deep we can get. That's number 1. And that's on one topic. Then if you have another topic that you need to go into, which I would say is probable cause, right? Reasonable articulable suspicion. Like, it makes me want to really try to figure out where was the probable cause and how did we get a probable cause here? Like, what happened at the probable cause hearing? I think what you did is you did upload those audios, which I'm going to have to listen within the next, 2 or 3 days. But now that you've gotten rid of the current lawyer that's on site, now that we've gone through these incident reports, now that I think everybody's kind of on point with helping you a little bit understand your case, I think you're going to be another Louis too that gets out there and wins, right? because these cops are doing foul things, and it's going to be so glorious to see you smile again and get all this fear off of you. But what I need you to really do now is get all the fear off of you now, knowing that we all telling you that this is nothing, like we can stop it. Okay. And
I got a good one.
Go ahead.
It's really simple. Are you able to state something that put you in fear at the time? Are you able to articulate what put you in danger?
It's
just a different way of saying the same thing you said, but let him go humana, because he's not able to.
Yeah, you got this. Don't trip. Just know that we're gonna help you all the way through this, and there's so many different plays of actions here that we can do. We just got to structure. Like I just showed you all Louis stuff. There's so much more I could show with Louis stuff, but you got so many different options. And we'll play with we'll see what we're going to get on this public defender. And even if you want, you ain't got to do the call with the public defender by yourself. If you're going to schedule a call, and you can get on the Discord with us. And we can listen to it, you know what I'm saying? And maybe give you some tips. You can mute the phone. We could say something like, hey, question him about this. Louis straight up asking me, he's like, hey, on my next court case, I'm going to just do it through Zoom. You can just be my co-counsel with me. I'm like, yeah, you should have been doing this a long time ago. You should have been e-filing. Why you keep going down there, bro? He's like, oh, I didn't know. I was like, I told you. So when I called, they told me I couldn't e-file. And then I call up there with him on the phone on three-way, and they say he can e-file. It's like, what? Come on now. So, yeah, I think we just got to prepare this week for you, start getting some stuff lined up. Now that we got the incident reports, that's very helpful because now we know what they're saying, which we can just combat that. It's so easy. They believe. Yeah, go ahead.
I'm supposed to be there on Wednesday for that rearrangement.
A rearrangement?
Yeah.
Oh, okay. Then I'm gonna talk to Zeke then, and I'm gonna get some ideas about this because we may be able just to right then and there do another probable cause hearing. And if we can do another probable cause hearing right there on an arraignment, that's going to be a big boy. You may be able to go in there pretty strong if you just got rid of your attorney and if you get something in there that you're going to say, because you can go in there just like this. Hey, I am not. I have an intro where I say, hey, you have to take what I'm saying as liberally construed because I'm not trained in the law. I'm here by special appearance again. I'm not waiving any of my I'm not waiving jurisdiction or any of my rights or anything. So I have a good script. You can come in there and first state your name as your special appearance, limited appearance, but it also comes in and it comes in a little bit strong, but you can read it and you can say, hey, I just need to read this into the court and into the record for any kind of appeal aspects. So you're letting the court know I have to put this in on the record, okay, for any kind of appeal aspects. And
I've done that before.
Okay, and normally they respect it. Did they respect you? Were they kind and let you speak a little bit?
Yeah, they let me go through my administrative procedures, and that was how I called it. I need to find. I think I found that video. I think I found the hearing. There's a lot of other people who went before me the second time that I didn't edit out of the recording, but maybe you want to hear that anyway, just so you can hear what they say.
Yeah, that's fine. I mean, I can fast forward and find it. It's easy for me. It's no issue. And then, where was that at? Where was that at? We was talking about just your process. But I think now that we know exactly what they're saying, we just need to start developing everything from an attorney's aspect. Because I want to say you might be good enough to go in there and argue, but I think I don't know. I think you should be more comfortable now with knowing that, their incident report looks really bad. You got a civil suit against you for all this irreparable harm that you've had placed against you. I think that should be where your mindset is set at right now. If we're going forward on something next week for an arraignment hearing, then we hit them hard on a probable cause. As far as probable cause and jurisdiction, very heavy. And maybe you can make some mentions. We can make some mentions in there for irreparable harm and develop something that you can read into the record. Yeah, I think you got some action. I think this week might come up and really turn up some good things. And if it doesn't, it's still going to turn up good because now we have the incident report. So
when I dropped off the paperwork on Friday, they told me that I needed to wait for the judge I have to wait for them to respond.
See, I'm not trying to be so. I'm trying not to be so excited as I want to be now that we read the incident report, because I know you're upset. But goddamn, girl, you got you a suit. I swear you do. You got your motherfucking civil suit for real, and it's a big one. Because they out here really arrested you on a belief in their minds that you hit them, but you didn't, and so they've caused all of this drama and travesty and harm against you on something that they can't prove. And if you could get over if we can get you over that trauma and get you to that empowering, Erica, that you fuckers did me wrong and y'all gonna pay. Y'all liable as fuck. If we can get you in that mindset and you empower that, oh, they're gonna be so fucking scared, bro. If you go to the next community meeting and you're like, this city is out of line and we have something to talk about in relation to Santos and Officer Blase Blase and Sergeant Blase Blase Blase, right? In relation to the beliefs of accusing people to hit them with, and I'm talking about putting it on the record in the city, bro. Like getting out there and really talking about what happened to you. Because now you have the incident report that shows that all it says is, I believe. Dudes out here illegally opening up your car door for no reason. What you talking about?
It's the intimidation part is that's the biggest thing when you go into a court. They're going to intimidate you. You got to remain calm so you keep your head clear and know what to say.
And from what I gather, that's not the first instance these things kind of happen, right, Erica?
He's got a Brady complaint. We're bringing that right on in as an attachment. What you mean? Huh? That's fuel for the fire. Huh? What? That is fuel for the fire, bro. Brady complaint. You already got you a Brady complaint, don't you, boy? Now you out here faking like I hit you with a crowbar. You said the first moment you saw the crowbar is when you turned around after dragging me out. Well, of course it's going to be on the ground. It was on the ground with my channel locks, next to all my rocks and stuff that I had been working on earlier when I put it back in the car. I had my car door open. And earlier I was working on some rocks, breaking them with my car door open, and I laid the channel locks and the crowbar right there with a couple of rocks that I hadn't finished breaking down yet. And I scooted them on back underneath my seat. That's the whole reason why I didn't break. I got my mom's urn in the back. It's got all her ashes in it. I knew I had the crowbar and the channel locks right up under my feet, underneath the seat. Knew if I braked hard, all that shit's gonna slide and I'm gonna have a hard time scooting it all back. I didn't see anybody in the way, so I just went on through because I didn't want to heavily brake as an emergency. In doing such, you want to pull me over. And then when you drag me out, of course my foot's getting dragged out and then the damn crowbar gets dragged out alongside. I would never hurt a soul. I've got no criminal record whatsoever. Now all of a sudden you're saying I'm out here with sovereign citizen ideologies, which I don't even see how you could put that in such a bad light, because in 1940 it's in a joint resolution signed by the president stating that that's the highest of citizenship here in America. You're putting it in a bad light as being free is something bad. I'm just so confused on what's going on here within this court today, and that's why I'm calling for a probable cause hearing and jurisdiction as well. There's no subject matter jurisdiction. There's no personal jurisdiction whatsoever. No one was harmed or hit. He even in his incident report says he believes. Well, the only aspect of how he believes that he got hit with something was because he unbuckled the seatbelt illegally and pulled me out. That metal seatbelt hit his ass. I watched it hit his head. I watched it as I'm scuffling, it hit his head. I watched it. I'm scuffling. I'm like, get off me, get off me. And I watch it hit his head. I look at it hit his head. And then his partner comes across and she grabs me too and gets my other arm because it's hooked up because I'm trying to hold on to the seatbelt so they don't pull me out. Because there's no reason for them to pull me out. So we need to redo this whole probable cause hearing. I need to send over to you, Erica, probable cause hearings.
I'd be careful, Cam, in saying that my foot dragged the crowbar out, because unless Erica knows that to be true, they may have just set her up.
That's exactly true. I had cowboy boots on, and the way the cowboy boot was, the way my crowbar was like this, where the hook was down, so I would never cut myself with the sharp end.
Yeah, but you're testifying, and I wouldn't say that because you know, what's the proof that they didn't set her up and put that crowbar out there?
I watched it. You can see it fall out. When she gets drug out, it comes out too. It all falls out. Just like his flashlight. He had a flashlight, and you can see the flashlight fall up under him, and they're dragging her. You know, they're pulling her on out. But he says, and what's so beneficial is he says, I reached in to unbuckle the seatbelt. That's golden. That's it right there. That's everything. That's your case. Case out right there, thrown out. Right there. You unbuckled the seatbelt. The seatbelt hits you in the scuffle. It's metal. That's what hits you. That's why you don't have no big marks. The crowbar and channel locks was under the driver's seat with all the rocks. So I got rocks down there. Because earlier in the day, I had the car door open and I put a whole bunch of rocks in my driver's floorboard. I had been breaking some and I put them under there and I was just ready to go. So I just pushed all of it back under the seat and started driving. That was earlier in the day. Well, they had been there all day. And then when I decided I was going to go see a friend, to go dancing. And that's why I didn't stop at the light. Because I had all that stuff up under me under my driver's seat. I knew it was going to fly up under all my feet. I'm driving. I'm not trying to have all that stuff mess me up. If you're hearing me, you're hearing me. If you know what I'm saying. Okay? And, hey, man.
Hear you.
When I just checked my email to get back in here, I found a email from my lawyer. He filed a motion to, I beat him to it, but he filed a motion to withdraw his counsel. Or please, Ms. Montgomery, please attached, please find a letter explaining our decision to seek leave to withdraw the motion to withdraw and the accounting of our time expended on your behalf.
Losers. Well, what I'll say is, Erica's got.
Do you want me to put this in the? Do you want me to put this in the Discord?
No, you don't have to. But what I will say is that Erica's got a very promising case. I hope everybody on this Operation Wisedome really kind of realizes that there's a lot of things. Like, we got people all over fighting their own cases, right? Erica is literally fighting her own case at this point. Louis is fighting his own felony case. He's been the whole time. But that these cops will say and do whatever they want, and you get fear. You know, fear gets brung into you, but you need to eliminate the fear. Once you eliminate the fear, you can move forward in knowing and start applying and making them do what they're supposed to do. Quit thinking that it's all you that has to do all the work in the worry. No, you just simply file something, make them work. They got to prove it. And with hers, she's over here worrying that they really try to, oh, well, you could get 40 years. She ain't gonna get no 40 years. She ain't even gonna get a day in jail, bro, because this about to get dismissed. And she's about to file a big boy civil lawsuit against not only those officers in their individual capacity, but also the city.
Hey, Cam, now that she got that letter from that attorney, would it be beneficial for her to go next week and ask for more time?
She can ask for more time, but what I would do is I think we should just set her up again for this next. They're saying she's about to go to an arraignment hearing, if that's what it's titled, and that would be a good time to bring up a probable cause, okay, and really go through some things as far as the facts are concerned. And if Erica goes in and says, based on what I'm seeing in these incident reports, that he unbuckled the seatbelt, then it's more than likely that the seatbelt is what hit his head and not magically the crowbar appearing from the floorboard up to hit him in the head. Okay, and again, probable cause hearings is something that I'm going to go through with her before she goes. We're going to definitely develop some things, and she's going to see some probable cause hearings to see how cases get thrown out, just like that, based on probable cause. Because if the lawyers ain't doing the probable cause hearings right, bro, hey man, this should get thrown out just based on the incident report and probable cause, just on that alone. Like, this incident report is not sufficient. Like, their incident reports do not support what the charges are. It don't support it.
None of them.
No, whatsoever. It can't support it. What they've stated on their incident report cannot support the charge or allegation. It cannot support it. Period.
None of them do, Cam.
Well, but that's what I'm saying. Whatever they've got on here, they don't support what they're bringing forward. So the probable cause hearing is really important. Now, should she get backed off to have somebody else come do it, like a public defender? I don't know. Can we develop something on the records where we really feel like I mean, you got to remember, probable cause can be brought up at any point in time. So even if it gets denied right now and you find something new to put in, like let's say we put in certain points that we think are hardcore, but not every point, right? We act dumb on one thing, two things, three things, okay? And you apply something and they're still denying it. Well, guess what? You still got 2 or 3 more things in your back pocket to shoot from as far as ammo is concerned based on probable cause. Because why? You can bring up probable cause on any new thing that's brought forth. Dig what I'm saying? So utilize that structure. That's the same thing I said with my Hood River case, bro. I shot just a couple. You dig what I'm saying? I want to see how y'all react. Then I came through after y'all answering. Are y'all ready to get on the? Are you ready to get on the phone now and talk about a settlement? You know what I'm saying? So, because I knew I always had 21 days as a matter of right to amend my complaint to and play chess instead of checkers. Okay.
Yeah. Don't put all your eggs in one motion. Right.
Yeah. Well,
So-
it seems as though we have a lot of more. David's coming out for a civil suit. I really want to actually get his as fully prepared up this next week as much as possible, just because I need more people bringing forth civil suits. Which we have David coming up. There's another person.
Need to be coming up soon. I want to do it.
Anthony should be doing one as well. Just do what
I
happened.
have a shitload of civil suits I can bring to you, Tam.
Hey, does anybody have this right here? Their certificate of live birth?
I do, but let me end this old bad boy for the Operation Wisedome for February the 8th of 2025. We done lost numbers now. We don't got an episode count no more. We go by the date.
Love you, brother.
3 hours, oh my gosh, and 36 minutes, right on time. That's always how it goes with me. Geez, Louise, it is what it is. I love you all. Everybody, y'all say unmute and say bye to YouTube. We'll see you on the next one.
Bye to two.
Thanks, Cam. Thank you, Cam.
Bye,
Bye.
everyone.
Bye.